Good morning, everyone. The time is 9:02, and I hereby call this February Citrus County Code Compliance hearing to order. We have an agenda for these hearings, and you might be not surprised to learn that the first item on the agenda is the call to order. The second item is the pledge to the flag, so I'd like to ask you to join me in the pledge to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning. If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of this proceeding is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay. The next item on the agenda is approving the minutes from the January 18th, 2023 hearing. I've reviewed the minutes. Does anyone have any objections or proposed modifications to the minutes as currently formulated? All right, hearing and seeing none, I will approve the minutes.
Staff update, abated, and continued cases are listed out front.
Okay. All right, good morning again, ladies and gentlemen. My name is Christian Waugh, and I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by local law, but all it means is that Citrus County has hired me to preside over your hearing. When your case is called, please come forward and you will be placed under oath. If you are appearing at a hearing like this for the first time, I'll state the alleged violation and allow the county to first present its case. You will then have an opportunity to present your case regarding the violation, which may include evidence and argument if you wish. During this process, the county attorney's office or myself may have questions of the parties, witnesses, or staff. I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. It is not an appropriate forum for personal attacks. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must abate the violation by that date, that is, fix the violation, or the fine will accrue for each day that you remain in violation. The law then allows Citrus County to use that fine as a lien on all real or personal property that you own, and the county may even foreclose on that lien or seek money judgment against you after the lien has been recorded for 3 months. This is important because I may not give you another date to appear before me, and therefore you likely will not have another opportunity to plead your case or to explain why you didn't comply with county law. The county will continue maintaining its liens until the county has been notified of your compliance. In all cases in which I find someone guilty of a violation, I'll impose all costs required by county law. If you abate or fix the violation in the time allowed, that cost will remain minimal. If you do not timely fix the violation, you will be responsible for additional costs as well as the cost of the lien imposed. If I find you guilty of the violation and allow for a continuance of your case, you will be required to return on a certain date. In the time between hearings, I'll require that you comply with the county law in order to consider the violation resolved. If your violation is not resolved by that next date, I may impose a fine for each and every day of the violation from today's date forward. Your failure to return on the date may be deemed evidence of your failure to cooperate with the county. Are there any appeals of orders to demolish?
No.
Okay. Ladies and gentlemen, you do have the right to appeal any order that I determine today at the hearing. Thank you very much.
First case on today's agenda, Patrick W. and Christina M. Gorey, case number 217-5241, Code Officer Jillian Nocella. Page 13 of your agenda. Experts on the case, Jeffrey Atkins and just Jeffrey Atkins.
Mr. Gorey, do you swear to to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you.
Thank you. Can you please state your name for the record?
Patrick William Gorey Jr.
Thank you.
Jillian Nocella, Citrus County Code Compliance Officer. This is case number 217-5241, Chapter 18, Article 1, Section 18-8A, obtain after the fact permits for all construction or modifications of the Citrus County Code of Ordinances. The address is 6800 West Green Acres Street, Homosassa, Florida, 34446. Property owner is Patrick W. Gorey and Christina M. Gorey. I have good service via posting at the property and the Lecanto Government Building. And I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A is photo taken during an initial inspection on November 1st, 2022. Photo taken at the corrective action inspection on December 30th, 2022. And photo from my final inspection on February 14th, 2023. Exhibit B is a copy of the notice of violation, a copy of the notice of hearing, photos of the posted property, and a copy of the posting affidavit.
Sir, what I'd like to ask you to do is take a look at these documents and take your time. But what I want to know is, do you have any objection to them being evidence in this hearing?
No.
Okay. Without objection, what's been proposed as exhibits A and B are evidence.
On November 1st, 2022, an initial inspection was conducted at 6800 West Green Acres Street in Homosassa in reference to information received from the building department regarding a pole barn built without permits. The structure was observed on the property and it was confirmed in our permitting system Hanson that no permit had been issued for this structure. No changes had been made to the structure at the corrective action inspection or final inspection. Per Hanson, a permit for the pole barn was applied for on February 15th, 2022. However, it was never issued. Mr. Gorey did come into our office and spoke with staff, advising he was working on a
Wait, I'm
building
sorry. Hold on. The permit was applied for on the 15th?
of 2022.
Oh, a year ago. Okay.
Yes. Mr. Gorey did come into our office and he spoke with staff, advising he was working on abating the violation. The expert for this case is Jeff Atkin, the assistant building director.
Okay. And would you like to testify?
Yes. Good morning, Jeffrey Atkins, assistant building official.
Good morning.
To confirm, yes, an application for a 20 by 36 pole barn after the fact permit was applied for. That permit was reviewed by the plans examiner on February 23rd, 2022. The permit application was denied. It needs a as-built plan, an engineered letter, and product approval for the structure. Comments were emailed out on the same date to the applicant of record. To date, we have no further information.
Okay. I just want to make sure I'm looking and understanding what the county's saying. So I've got Exhibit A, pages 1 through 3, and it looks like, is it this structure?
No, sir. It's the larger, kind of in the middle,
Right here.
wooden siding.
Okay.
Yes,
All right.
enclosed pole barn.
And does the county know when it was built?
Pictures on the property appraiser's website show in 2019 it was not there, and then the next photo is in 2021 and it
Okay.
was being constructed.
All right.
So sometime between that.
Okay. Mr. Gorey, is it? Well, what's going on?
We moved here in August, and I wanted to put the outbuilding there. I priced out a couple buildings that were just outrageous. So I bought a pole barn kit, and as a kid, I've never dealt with permitting or whatnot. I wasn't sure what the procedure was, so I built the kit. After looking at the pavilion or the empty pole barn uncovered, we decided to cover it, which at one point we got a stop construction notice on the gate, and it's kind of been sitting there ever since. I was told that I needed to get the after the fact permit. Calling around and speaking to different engineers, I guess I was asking for the wrong thing because none of them knew what I was talking about. I came in and I submitted for the permit. I was told that 2 of the 3 things that needed to be approved were approved, that the building was not. Then I was told again that I needed to get an engineer letter, so made some more calls, and I was told that what I'm asking for didn't make sense to the engineer. So I came in and I spoke with the secretary, and she said, no, you were asking for the wrong thing. You need to have your original plans redesigned and make sure that your building is built to the new plans. Which made sense, but had been the first time that it was explained to me that way, so I knew what to go after. Now, this was only, I think, 3 weeks ago. So I was told at this point to just kind of put everything on hold, wait till the day, come in.
You
So-
didn't build based on
built-
the original plans?
No, the actual pole barn is built to the engineered plans that were submitted, but I wrapped it. I put the sides and stuff on it, which were not part of the original plan. So it's been modified from what I had submitted.
Okay.
Um,
Let me ask the county, I mean, is there any way for is the county aware of a way to approve that after the fact?
To approve the modifications?
Correct.
Absolutely. Again, because it was modified from the original set of plans that I'm hoping were certified by an engineer in the state of Florida. Because it's already been constructed, that would be an as-built set of plans. An engineer of record would come out, would gather the information, certify that it was constructed per the Florida Building Code. That's where the letter comes in. He can either certify the plans or he can certify a separate letter. At that point, that would be reviewed, hopefully approved. If everything is on the letter, then we would come out and do a final inspection based on that information.
Does that make sense to you, Mr. Gorey?
To me, yes, but when I mention letter to the engineers, they tell me they don't know what I'm talking about.
Well, what he's saying is someone would have to go out there and certify that it was done per the Florida Building Code, an engineer, presumably.
Now, I did speak to an engineer who asked me what they wanted my letter on because the building was never finished. They don't want to write a letter stating
Oh,
that
I
it's
see. It
built
wasn't finished.
to plan
Okay.
because it's not done. Now, I was actually willing to unwrap it, if that was the case, to get it back to what the plans were that were submitted, so that it was exactly what you guys have on record here, and then apply for a second permit to enclose it and
If
have,
you unwrap it, will it correspond to the original plans?
it'll be
precisely?
exactly what the
Okay.
original plans
All right.
were.
How much time do you need to either obtain an engineer inspection based on what you got and provide the county what it wants, or bring it back to the original plans and then get that certified in a way that the county wants?
Financially and physically, if I could get between 60 and 90 days, I
Okay.
can have everything wrapped up.
What's the county's recommendation? Actually, first let me ask, does the county have an immediate health and safety concern with the structure such that it wants it demolished or anything like that?
No, sir.
Okay, then what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owner once they were advised of the violation. We would also ask the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Is there anyone from the public who wants to be heard on this case? Okay, seeing none, here's what I'll do. I will find that the property's in violation. It's essentially been conceded. I'll grant 90 days from today to abate the violation. If the violation is not brought into compliance as ordered within that time, a penalty of $50 per day will be imposed, and that fine would be recorded and constitute a lien on the real or personal property of the Goreys. The county attorney's office may seek foreclosure or money judgment on any unpaid lien of record 3 months from the date of first recording. And the property owner shall be responsible to pay all costs required by county law, which may also be filed as a lien of record. And for the rest of the hearing, those last two sentences I'll just refer as the standard order provisions.
Okay.
Okay? Thank you.
Thank you.
Is that it?
Yep.
Thank you.
Next case on the day's agenda, Michelle David, case number 216-1603. Code Officer J.C. Charlton, page 8 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Page 8?
Yes, sir.
Okay.
Good morning.
No, this isn't getting called.
Okay.
At this time.
Page 8 is not being called?
Correct, we have a stipulation, Your Honor.
I wish.
It was not supposed to be called.
Okay, okay.
Thank you.
Then I guess you don't need to talk to me. Have a good day.
Next case on today's agenda, Charles R. and Gail E. Stahl, case number 217-5984. Code Officer Brandon Norman, page 22 of your agenda. Expert on the case, Jeff Atkins, certified building assistant.
Okay.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Welcome back. I do remember this case. I think basically where I left it is I wasn't ready to make a decision because I felt I had incomplete information. And I asked the sides to find a way to get me the information I needed to determine one way or the other. Is that right?
Yes, sir, that's correct, yeah.
Mr. Stahl, have you been in communication with the county about this case since the last hearing?
Yes, sir. I've got an after-the-fact building permit. I applied for one, and they gave me one.
Okay.
Per our research, sir, it was determined that there has been a permit that has been issued for the roof construction. We have also have some more information as far as the modifications to the living quarters inside the barn. Jeff Atkins.
You're telling me this hasn't abated?
This is not abated, no, sir.
Okay.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 2175984, construction or modification of a structure without required permits. A violation, Chapter 18, Article 1, Section 18-8A of the Citrus County Code of Ordinances. This is for 5770 South Cherokee Terrace, Inverness, Florida 34452. Property owner listed as Stahl Charles R. and Stahl Gail E. We have good service via certified mail return receipt for the continuance. Exhibits A are going to be photos taken during the initial inspection of November 4th, 2022. Photos taken at the compliance inspection of December 27th, 2022. Photos taken at the first pre-hearing inspection on January 17th, 2023. And photos from the last inspection on February 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the continuance letter, and a copy of the certified mail return receipt for that continuance letter. Exhibit C's will be a copy of the property appraiser summary pages from tax year 2023 and 2021, and a copy of a Citrus County residential contact data card.
What was the last thing? A copy
A
of...
contact data card for the property appraisers.
Oh, okay.
Mhm.
Okay. Well, Mr. Stahl, I'd like to ask you to take a look at what the county has and let me know if you have objections to them being evidence in this hearing.
It's all the same photos from before, except for the last photo, which will be the February 14th.
Okay? It's the original one. Okay, I'm not sure what to say. It's all good.
Okay. I'll allow county attorney review.
Showing different photos of the last one from the last inspection. Everything else is the same photos from the previous hearing. This is to see the property summary, or the property appraiser summary pages for 2023, 2021, and then the contact card that the property appraisers had.
What's been proposed as exhibits A, B, and C are evidence. So also my recollection was that let's start from the beginning. I think the county, you had included the roof in your case originally, didn't you?
Originally,
So
yes,
that
sir.
part has been abated.
That part is
That's done.
abated.
He successfully abated it.
Yes, sir. We're okay with that one.
Now, the second thing is, this is just my recollection, is that I was concerned that the modifications the county was saying were a violation were performed prior to the county having the applicable law. In other words, it was my concern that the property owner or his predecessors may have made the changes before it became illegal to obtain the permit for the changes made. Is that your recollection?
Yes, sir.
Okay. And what does the county learn?
So this is a continuance from the previous hearing held on January 18th, 2022. The county was asked to research the property for more information to determine if the additions and modifications were made to the barn occurred after the administrative acceptance of structures built after the prescribed time.
Right.
A permit to re-roof the garage was issued on January 25th. At this time, I would like to ask my expert witness, Jeffrey Atkins, Citrus County Assistant Building Official, to explain what was discovered in regard to the upgrades made to convert part of the barn to a living space.
Okay.
Morning, sir.
Hey, thanks.
Jeffrey Atkins, Assistant Building Official. To update on both the permits, the re-roof permit 2023, permit number 2023-00307 was issued on January 18th. It has not been completed to date, so it is an open permit. With regard to when the modifications were made to the utility structure, I refer you to the Citrus County Residential Data Card, specifically the notes section. There are some dated comments in here, but the one of interest is 6/24/2014, where it says sink, shower, toilet in DLM, which is a detached building according to the property appraiser's codes. Fix EPM conversion to MLA, which is a carport to main living portion of DUM, which again is that storage building.
I'm having trouble following where you're at. So I have the card.
This portion,
Okay, that portion.
yeah, the notes.
Okay, all right.
And it basically, it states per owner. If you look at line
I see
2,
it. I see it.
6/24/2014, which basically, my interpretation is this of the tax representative or property appraiser's representative, at some point per the owner, there was a sink, a shower, a toilet, and that structure was converted to living, not utility. And that's the earliest record I can find of that particular change.
Mm-hmm.
If you notice, there's a June comment, and then the comment before that is 1995. So the tax card had not been updated since 1995. But as of 2014, again, per owner, that structure was converted to living.
Well, Mr. Stahl, are you aware of why it would say this with the property appraiser?
No, sir, I don't, to be honest with you. Because it's in the barn, it's not really a living quarters, okay? Never has been. The barn was there originally with the utilities in it.
Yeah, I mean, let me talk to the county about this. So in the notes, let's see, locked gate, June 12th, 2014, and then June 24th, 2014, sink, shower, toilet in DLM per owner equals fix.
Right. And if you look at the first line, changed rate from 6,500 to 4,500.
Mm-hmm.
That there was a correction on his accessory structures. Basically, the number of accessory structures, my interpretation of this has gone down. And then on June 24th, that was fixed or corrected to living, not storage.
But this could indicate I mean, are there any other records the county has?
No, this is the only records from the property appraisers that I could find that actually recognized an accessory living structure beginning 2014 for the tax assessment that year.
That doesn't actually mean, well, I know what it means and doesn't mean. So, Mr. Stahl, when does, actually, let's get this on the record. So what does the county want after the fact permit for at this point?
At this point, it would be conversion of that accessory structure to living, which would be like this previous permit, an as-built floor plan and certification of the inspections that we cannot physically do because the conversion was completed.
When did that conversion occur, Mr. Stahl?
It's been like that since the garage was up.
When was that?
Late 80s, 1980. Probably around 89, I would say.
Let me just take a moment to look through this. In one part, it does talk about a detached living area, wood, 1978. That's before, I think, that there were changes made, if I'm reading this correctly.
That's when we moved in, if I'm not mistaken, and like I'm saying, the barn was there with the utilities in it.
Well, there's a warranty, well, there's a contract and agreement for deed in 1980, and then there's a warranty deed in 1983, so I presume that it was paid off in about 3 years.
Yes, sir. Well, actually, we refinanced. That's
Okay,
what we
no,
did.
that's fine. Yeah.
Yes, sir. It was never intended to be a living space.
Right. But I see, and so what the county's done is they've correctly matched up what it was like before and how it was assessed with how it became assessed in 2014. What's lacking is the notion that it in fact occurred in 2014. In other words, property appraisers are often far behind the curve, and there's no testimony that he just did it in 2014. In fact, the unrebutted testimony is that he did it in the 80s. So I'm going to dismiss the case.
Thank you, sir.
Thanks.
Thank you very much. Y'all have a great day.
Next case on the day's agenda, Natalie Ray, Corey Hollis, Andrew Hollis, Laura Gilmore, Paul Hollis, Terry Hollis, and Joan Hollis. Case number 217-9068, Code Officer Amy Becker, page 18 of your agenda. Experts on the case, Joanna Coutu and Jeffrey Atkins.
You don't have to look in. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-9068, a violation of the Citrus County Land Development Code, Section 3101I, 1A through C. Residential pools shall have pool safety barriers maintained. The address is 229 West Casarina Place, Beverly Hills, Florida. The property owners are Natalie Ray, Corey Hollis, Andrew Hollis, Laura Gilmore, Paul Hollis, Terry Hollis, Joan Hollis, Francis Newborough, and Mary Ann Hollis. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on December 28th of 2022. Photos taken on January 13th, 2023, and my corrective action inspection. Photos taken on my final inspection on February 14th, 2023. A copy of the violation, Exhibit B, a copy of the violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt signed for on January 19th, 2023.
Is there anyone from the public who's going to want to be heard on this case? Okay, thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
On December 28th of 2022, I was allowed access to the neighbor's property and observed the swimming pool was not secure. Part of the privacy fence was down, leaving a large gap, allowing access to the in-ground pool. As of my final inspection on February 14th of 2023, there's been no change. I have had contact with Paul Hollis and Andrew Hollis.
And what did that contact entail?
On January 3rd of 2023 at 11:07, I spoke with Paul Hollis and advised him of the violation. I asked him to contact me when he was ready for inspection. And then on January 10th, I spoke with Andrew Hollis, advised him of the pool violation and other violations at the property, and told him to call as well.
Did they indicate that they agreed with you, that there was an issue, or?
They agreed with me and they said they'd get to it.
Okay. Is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development, a residential lot. There is a pool there. Our Land Development Code, in addition to Florida Building Code and Florida statute, says you have to have a barrier of residential pool safety.
Okay. In the county code I know that with the my recollection with the statute is that there's a kind of a grandfathered year issue where, and I don't remember what the year is, we can look it up, but if a pool was constructed like before 2001 or 1999 or something like that, then it's not subject to the statute, I believe. Now that's neither here nor there for the county code regardless.
Right.
Do you know?
I have the statute here. It does not say anything about year built, but I'll be glad to give that to you. And the county code, of course, does not at all.
Do you know when if the code section passed in 2005 and the pool was there in 1995, is it the county's position that they would be required to, bless you, then build the barrier?
It's the county's position that they would have to comply with Florida statutes. The pool just recently, my understanding is a fence panel was missing. So it's just a recent violation in this particular case.
I'm just going to look up the statute here. Oh, thank you. Awesome. So this Florida statute was passed in 2000, and it does not have doesn't mention anything about grandfathering things in, but if we look at the act itself, okay, so there are a bunch of exemptions in 515.37. This chapter does not apply to any political subdivision that has adopted or adopts a residential pool safety ordinance, provided that the ordinance is equal to or more stringent than the provisions of this chapter. So this doesn't even come into play if your pool section is equal to or more strict.
Which ours is defaulting to that, but not limited to, and then spells out basically the same thing of the
Okay, and
barrier requirement.
where is it in the code?
R4501.
Well, that's the building code, isn't it?
No, what's the citation, Nina?
It's a 3101, 3101 I-1A.
Okay. Okay, I see it. All residential pools shall have. So this is interesting. The county code only refers to 515.29, and the exemptions say that, the ordinance, in order for the county ordinance to take precedence, it would have to cover everything that the state law does, but it doesn't do that. So I agree that the state statute is still at issue. It's a valuable perspective. I'm just going through the statute real quick because I remember there being
Right, that's what I put it.
a timetable.
We also have the assistant building official here because we do reference the Florida Building Code as well. This
Right.
appears to be. Now, that wasn't cited because it's mentioned in our LDC ordinance.
Yep.
And so if you need his testimony as well, they're not going to be reflective of when the pool was built, but the fact that this is a safety issue.
It is a safety issue. I just want us to narrow it down and make sure that if there is a violation, it's based on correct law. All right, let me look at the exhibits again. Hmm. 3101, 1A through C. Okay, who from the public would like to be heard? I saw a hand go up. Right. If you don't mind, ma'am, come down and take an oath.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And can you please state your name?
My name is Cindy Burke.
Thank you very much.
My husband and live at 243 West Casuarina, so we're right next door to the Hollis property. Yesterday afternoon, I did take a close-up from my property of the pool. So we're not talking about a very clear pool. We're talking about something that has enough algae in it. There's 3 little boys that live directly behind us, a 6-year-old directly behind that house, and a 6-year-old right next to the other side of the house. Our fear, as being grandparents, is that one of these children, with the gate being down, would fall into the pool.
Yeah.
And with the amount of algae, it's definitely going to pull them under.
Well, I can actually tell that from the photos that the county has. It's not a clean pool. It's not a clean area. It's perhaps vaguely radioactive.
I would agree.
So my one concern is just the age of the pool and if it can be regulated based on the current laws. So, for example, sometimes there are times when, if something's built beforehand and then a law is passed.
Right.
But I am actually going to find a violation exists based on the county code, and the notice of violation mentions the county code, not the Florida statute, which I think works. So, what would you like to see done?
Definitely the gate to go back up. The fence that's holding the gate itself is now leaning in. There are nails this long sticking out of the gate, so if anybody stepped on them, and they are old and rusty. I'd just like to see the property cleaned up. I have seen no one since county, notified them of this. We have seen not a single person from the family at that house.
Okay.
So they're making no attempt, to do anything. And the previous violations from last year, all of them are still ongoing.
Does that conclude your public input?
Yes.
All right, I appreciate that, ma'am. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with administrative costs begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Do they need a permit to fix this?
No.
Okay.
No, they do not.
Okay. Then I find the property in violation. The property owner is granted 21 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $150 per day will be imposed. This fine will be recorded and constitute a lien on the property owners, and I incorporate other standard order provisions.
Next case on the day's agenda, Brianna M. Schaefer and Brian Earl Sterling, case number 217-8126, Code Officer Amy Becker, page 21 of your agenda. Expert on the case, Jeff Atkins.
Hi,
Hey,
I'm the actual property owner. It's kind of a long story.
not her?
She's with me.
Okay.
And I apologize, the person I was supposed to babysit had
Oh,
a,
that's
had
okay.
a Shan's appointment, so I couldn't.
I appreciate the color.
Oh, sorry.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Can you please state your name for the record?
My name is Kara Cachopo, and this is Peyton.
I'm sorry, so you're not the owner?
No, I am the owner.
You are the owner.
Yes, my husband passed away before all this took place, and it's right now being dealt with, so.
I'm sorry to hear that, but who was your husband?
My husband was Vito Tuminello. I did bring his death certificate.
Okay,
So-
I just don't see it listed on the property appraiser
Correct.
card.
It didn't get recorded in time, and he died of an accident and wasn't expected before it got recorded. So I have a lawyer that's dealing with that and getting it all put in my name.
Okay,
as
well,
we
I find
speak.
you have standing, so please proceed.
Amy Becker, Citrus County Code Compliance Officer. This is case number 217-8126, after the fact permit, a violation of the Citrus County Code of Ordinances, Chapter 18, Article 1, Section 18-8A. The address is 2451 West Landmark Drive, Citrus Springs, Florida. The property owner, according to the property appraiser, is Brianna Schaefer and Brian Earl Sterling. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on December 22nd, 2022. Photos taken on January 19th, 2023 in my corrective action inspection. Photos taken on January 31st showing the posting of the property. And photos taken on my final inspection on February 14th, 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit.
Ma'am, I would like to ask you, if you can, to let me know if you have any objection to these documents being evidence.
Tell me if you want me to stop.
No, go ahead. You said there was one where it was served because I was never served everything.
It's when I posted the property, it goes to the PA, the property appraiser for the statute, so
Well, let's have that on the record if we have concerns about service. I just want to make sure that the microphones pick it up. But let's just talk.
She called me, and that's why.
That's okay. Let's talk about the documents first.
Yes.
Do you have any objection to the documents being evidence in the hearing?
No, I brought the same picture.
Okay,
so-
all right, okay.
Yes, baby. No, you can't touch that. Here, hold the keys. Okay.
Pardon?
Is there a house there?
There's a
Yes.
house there. They did a lot reconfiguration.
Thanks. Okay, without objection, what's been proposed as Exhibits A and B are evidence. Now, we'll talk about service. First, I let the county present its case, and then okay, go ahead.
So on December 22nd, 2022, I observed a shipping container and 3 sheds at the property. Upon arrival back to the office, I did not find any building permits. As of my final inspection on February 14th, 2023, still no permits. I have not had contact with the owners. On January 27th, this young lady contacted me and advised me she purchased the property from her daughter, Brianna Schaefer, and the sheds on the property were there when she bought the property. And on January 31st, I spoke with her again and advised her that she needs to have a permit for the structures. So it's a shipping container, a pink shed, a green shed, and a gray shed, which you can see in the photos.
Is this, all right, is there anyone else from the county who wishes to testify? Hate to have you walk all the way up and not.
I just stayed up here. Good morning, sir. Jeffrey Atkins, assistant building official. I did a permit research for this particular address. I found a 2021 mobile home permit that has been since issued and processed and closed out. No permits for any utility structures, including sheds or storage containers. Storage containers, I will say, most people consider them a portable building, but they are required to be properly engineered, anchored, and
Well, that's what I was going to ask. I mean, if it's a prefabricated storage container, and the county also has the alternative of if it's a vacant. I don't know if it's a vacant piece of property or not, but without the principal residential structure being there, it's being used as storage. Are you saying that they, even with a prefab storage that could just be dropped down, they need a permit?
yes, because most of the sheds that you purchase from roadside vendors that we have are prefabricated sheds that meet the Department of Business and Professional Regulation certifications at the time of manufacture. The storage container conversion to a storage shed, for us, it's merely the anchoring and how it is affixed to the ground so that it is firmly fastened to the ground like a DBPR storage shed.
Okay. All right. So you've heard the county's case. I think I understand it now. I will say at the onset that just because there's a violation before you got it doesn't alleviate the current owner of having to rectify it, if that makes sense.
It does.
But what's your perspective on what's going on here?
Okay, so we have over 10 acres there.
Okay.
And we were in the process before my husband passed of turning this over to ag, at which point outbuildings become a different story. He died, things became complicated. They had a medical hold on his body. I wasn't able to get a death certificate. I'm sorry. I wasn't able to get a death certificate right away to deal with stuff. We went to the attorneys. I don't even know how they got my phone number, but they got my phone number to figure out to get a hold of me. So me finding out about this was just before his funeral, which was February 4th. So,
And I'm sorry, ma'am, February 4th of
was this year was when my
of
husband's
2023.
funeral was. So she actually called me on the phone.
Okay.
The service of Fort Island Trail, there's new owners there. I don't know who would have signed the paperwork. I know it wasn't Brianna or Brian because they don't live there because we sold that house. So, I contacted Dan Ogden. He's somebody I work with. I do landscaping, and he was in the process of trying to get everything with me. The shed that was there, so that we can understand, the one shed in your picture was brought there by the mobile home movers with the mobile home when it was set up on the property. So we were told that shed was all in that permit. If it wasn't, I didn't know. Can I approach for a second?
Well, just one moment. So in looking through the materials that Ms. Becker's given me, I want you to know, in the affidavit of Amy Becker, paragraph 3, it says, due to the inability to serve the notice of hearing via certified mail or hand delivery, on January 31st, 2023, I posted a copy of the notice of hearing on the
Yes.
subject property.
This is the notice that I.
Well, that's valid service.
Yes. That
Yeah, okay, I just want you to
I was
know.
talking about before that.
That's okay, it's irrelevant. So,
Okay.
there is valid service. I can't review things on your phone unless you want me to take the phone as evidence, which I think is a bad idea.
Well, I don't know how to
Well, tell
deal
me
with
what you
this
want.
because they're doing from the road, and this is a greenhouse. One of the things that they're considering is a shed, which is just a portable thing that is moved around depending on where the sun is.
Right.
So I'm not sure how to address that with anybody.
Have you
And
had any discussions with the county about these sheds at all?
She had called me on whatever day she said, because I got a message through my phone. I don't even know how they got my phone number.
You mentioned
Know who
that.
to call.
Yeah.
And then I called them back.
But you'd be amazed what you can find on Google, ma'am. I mean, it's,
Well, I think it's probably the person who, because they told me one of the neighbors had called and complained, and we
Okay.
are having an issue with a particular neighbor over there, because every time we do a burn in our legal burn permit, we end up with the fire department, police department. I have to give the permit numbers every time, so that neighbor has my phone number because
Okay.
we were trying to be nice when we moved in. I got a hold of Mr. Ogden, like I said. We just yesterday, I was able to get, these are engineering papers for the sheds. Because they were actually, the sheds that they're talking about, the one shed was there when it got moved there by the mobile home from Itchitacha. The sheds that were not there prior to that were these ones. And they were given to me, and I think I told you that from Chappelle Court. They were on a property in Hernando, and my client wanted them off his property and gave them to me. So they were sat on the property. One was put on a spot.
there we
One was
go.
put on a spot, anchored down properly. The one, can I see your pictures? There's
Well,
one.
I mean, look, hold on. Let me, if you don't mind. So there's 1, 2, 3, it looks like 4.
There's 3 sheds and a shipping container. There's a yellow
Okay.
shipping container,
Okay.
and there's 3 sheds.
Okay.
And the shed that was supposed to be on the permit was, I did not see it
It
on
was
that
the
permit.
pink, it's the one that looks mauve.
Okay, I see it. Yep.
Okay, but what I'm talking about specifically is the 3 sheds and the shipping container. That is all.
No, I
That-
know.
that is all.
I know.
Yeah.
So the one thing that they're saying is a shed is up close, because you guys have only been to the road, from the road is a Home Depot greenhouse.
Is that the green one?
Yeah, I have to move it all the time depending on the sun, because if it gets too much sun.
Yeah, what she's showing me on her phone would still need a permit.
And that was my concern, man. That's why I
I
asked
didn't
them.
know.
That's why I asked them the questions in the beginning, because I also was a little bit confused about that. That's what the county requires here. So
Yes.
what I think you need is time to figure it out with the county. There is a violation. I'm gonna
Yes.
find a violation.
And I have, like I said, just yesterday, we went to Smithville, and, sorry, we went to Smithville, and they provided me with stuff for Mr. Ogden, because I work with a contractor. I asked him to help me with this, and there you go. So, Mr. Ogden's supposed to be getting the permit. I went and picked this up yesterday for the 2 sheds.
I'm not worried about good faith. I'm not worried about progress. I guess what I need to know is how much time do you think it'll take to fix this?
Well, it depends if they want it in my name or if they'll let me file it in the name now, because
Yeah.
the lawyer's trying to get everything in my name, and I'm 60 to 90 days out on that. I'm not sure exactly how
Well,
long.
I mean, I'll just say it. When did you buy the property?
So the property got bought just before my husband died.
I guess what I'm
26.
looking for is a date.
Oh, I think it was like the 15th or 16th of November, everything transferred
Of
over on the deed.
2022,
Yes.
and there's a deed that shows this somewhere?
No, we had just got it. We hadn't recorded it. And
No,
he
no,
got
I'm not
it.
asking about recording. what I'm asking, is there a deed that is signed?
Yes, there's a
Okay,
deed
that's all I
signed.
want to know. Now, recording can be done like that.
Yes.
Literally, you can walk it down and record it.
The lawyer is suggesting we wait to do it because they want to do a different closing in my name so that we avoid some problems with this.
Were you married to your husband at the time?
Yes.
Then it really wouldn't matter whether you're listed on the deed as joint tenants of rights of survivorship or, I mean, did he have children from another marriage?
No.
Okay, then it wouldn't matter if you're tenants in common or joint tenants with rights of survivorship. I'm not your lawyer and I'm not gonna get legal advice, but what I am saying is, first of all, the deed is active upon signing.
Yes.
So it doesn't need to be recorded to be valid.
Okay.
All right, so I'm going to suggest that that's actually not an issue for you.
Well, I don't know.
And the
This
county
is-
may want to see the deed. They may also want it recorded, but let's set that aside. How much time do you think you'll need to otherwise fix the problem?
What do you need with the shipping container? Because we were told there's no. It's anchored down. The thing's like 40 foot long and weighs 1 million pounds.
Right, the 90 days would be a good amount. However, with that caveat being said, if she's deciding to go agricultural, then that opens up, in other words, then that opens up a whole nother.
Aim.
The issue about agricultural, I don't believe has any bearing on this case because it wasn't agricultural when those buildings were.
Oh, of course, my mistake. Okay, so 90 days.
Well, I agree. I agree that it doesn't have any bearing now. I guess I also don't know if it would have any bearing in the future, to be honest.
That's what I'm trying to.
Yeah.
I don't believe that it does because it has to be farm operation for 1 year.
Yeah.
In order to.
Right.
And it is farm operation. We have hogs, chickens, everything.
I'm not sure that fixes your existing problem with prior zoning, or classifications. So ultimately, you're suggesting that you think 90 days with your, not pinning
I'm
you
thinking
down.
permitting, as
Yeah.
far as how long it's gonna take permitting
Okay.
for the shipping
And it looks like
container.
she's already making pretty
Progress.
solid progress on this.
And the green shed, I will just tear down because it's just a mobile.
And that'll help. That'll help get rid of violations as well if you take things off the property or whatever. Is there anyone from the public who wishes to be heard on this case? I don't see any hands. All right. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Ma'am, I am going to find the property in violation. I'll grant 120 days to abate the violation. If the violation is not brought into compliance as ordered, I'll adopt the county's proposal that a $50 per day fine would be imposed. The fine will be recorded and constitute a lien on the real or personal property of the owners. And I'll incorporate the other fine provisions. I encourage you to keep in touch with the county on every step of the way.
Absolutely.
Okay?
Thank you.
That's it. Thanks.
I just need to get with you and find out what I need to do with that shipping container. So, because that is anchored down. So. Thank you, I appreciate it. And I'm sorry about Aiden.
Oh, not at all.
Next, 3 cases on the agenda. Crystal Stiegler, case number 217-5664. Code Officer J.C. Charlton, experts Jeffrey Atkin. Case number 217-5663. Code Officer J.C. Charlton, expert Joanna Coutu. And case number 217-5662. Code Officer J.C. Charlton. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And you're Crystal Stiegler? Yes, ma'am. Thank you.
Did we have a case with you last hearing?
Like a couple weeks ago.
Okay. All right. Well, welcome back.
Thank you.
Good morning.
Good morning.
J.C. Charlton, Citrus County Code Compliance Officer. This is case numbers 217-5662, 217-5663, 217-5664. Unlicensed inoperable vehicles, violation of Chapter 20, Article 4, Section 20-41, and a violation of Citrus County Land Development Code, Section 3730, animals, and violation of construction modification of a structure without a permit, a violation of Chapter 18, Article 1, Section 18A, 8A of the Citrus County Code of Ordinances. The address is 6901 West Arlington Place, Homosassa, Florida. Property owner, Christelle Stiegler. Good service via posting the property and at the Lecanto Government Building. I would like to authenticate the following documents and request it be admitted into evidence. Exhibit A, photos taken during the initial inspection on November 16th, 2022. Follow-up inspection on December 30th. Corrective action inspection on January 17th, 2023, and January 24th of 2023, and my final inspection on February 14th, 2023. Exhibit B, the notice of violations, notice of hearings, photos of the posted property, and a photo of the posting affidavit.
Let me ask you this. So are the photos the same for all three of the cases?
No, sir.
Okay. But you have exhibits A and B for each case?
Yes.
And the photos taken in each case are from the dates you described?
Yes.
Okay. Ma'am, I think you know what I'd like to ask you to do is to look through these documents, take your time, let me know if you have any objections. I remember your objections from last time, so I know you're capable of making objections. Just let me know.
So is this the, I know which trailer this is. So is that considered the inoperable? Well, that's not a vehicle. Is this a rubbish one?
Well, so we'd have to get into that. For these photos, what I want to know is, so you're going to be allowed time to comment and criticize whatever is in them. But I guess what I'm wondering is, do you have any challenge to their authenticity or any reason to believe that they're doctored in any way?
They're correct.
Okay. I mean, but take a look through them and let me know. I want you to be sure. I'll probably have the same questions, but I haven't seen them yet. And is there anyone from the public who's going to want to be heard on this case? Okay, thank you.
My chickens are so photogenic.
They usually are.
I trust that everything is correct.
You trust the government? I'm not because I also trust them, but you know.
Some of the pictures are pretty shady looking pictures, like I don't take care of my animals, but they are well taken care of. I can assure that.
Well, I don't think that's going to be the issue here.
There's just too many.
I haven't seen this code section before, but I'm interested to review it.
Oh, okay, backwards.
We just found a clutch of 11 chicks that a hen hatched outside under the shed. So
Wow.
I'm finding homes for them.
This is a fairly permissive animal regulation code section as far as they go. I mean, in various counties. Well, if I tried to get away with cattle in Orange County, I'd have something coming for me. All right, so I didn't hear any objection to what's been proposed as either Exhibits A or B in any of the three cases. I'd like to hear from the county.
Conducted initial inspection on November 16th, 2022. I observed an inoperable trailer and a trailer with an expired tag on the back of the property. I received access from neighboring properties to view all violations. I also observed 10 to 12 hens, roosters, and 2 lean-to type structures on the property. I've had contact with the property owner and explained the violations. On December 30th of 2022, I met with the property owner at the property and observed turkeys as well on the property, and 2 unlicensed trucks on the property as well. While at the property, speaking to property owner, Ms. Stiegler, she stated that the animals were pets. As of my final inspection on February 14th, 2023, all items remain on the property at this time.
All right, so let me just try to look through all this before I ask Ms. Stiegler any questions so that I understand what's going on. So it's the county's, the case number 2175664 regarding the after-the-fact permits, that's for the lean-tos?
Yes, sir.
And the animal code violation, is that for the turkeys and the chickens? Is it just for one or the other?
And then for both, and
It's
the
for both?
roosters.
And
Yes,
for
sir.
roosters?
Yes.
Okay. All right, and then on the unlicensed vehicles, how many, 2?
I observed the trailers initially at the initial inspection, and then when I was on the property speaking with the property owner, I observed the 2 unlicensed trucks as well, and they've been there through corrective action and final inspection.
So it's trailers and trucks?
Yes, sir.
Do you know how many trailers?
There were 2 trailers.
So 2 trailers, 2 trucks?
Yes, sir.
Okay. All right, let me look. Looks like a fun place. Got animals and all kinds of stuff. Well, it's well documented. Okay. So, Mr. Charlton, before, I've never reviewed 3730.
Yes, sir.
I'd really like to because it looks interesting. But what exactly, is there a limit, or are the turkeys, rooster, are they completely forbidden? What's the issue? Okay.
It's based on zoning and lot size. So this is medium density residential. There's a very specific criteria for medium density residential. You have to have 2 acres in a house. This is less than a half acre, just under 0.48 acres. So medium density residential rules out everything on the animal schedule, not an option. Now there is a provision later in 3730 that says animals as pets, and it would allow up to 4 hens, but it specifically prohibits turkeys and roosters as being in that class, and also the 4 hens is it. It's cut off no more than that. So we've got some violations there, 4 hens perhaps, but that's it. No turkeys, no roosters, and no more than 4. And there couldn't get a conditional use because they don't have the minimum acreage for that zoning.
So you're saying that for this parcel, turkeys, period, have to be gone?
Correct.
And anything above 4 hens has to
Correct.
go.
Correct. And no roosters, no.
Have to go.
Right.
Um,
It's not the zoning. There's some rural zoning
Right.
that could, but this is not
right.
one.
Okay.
It's just too small
Okay.
to.
That answers my question. I see everything else Mr. Charlton is talking about in the photos, so I'd like to ask you what your perspective is on this.
So literally, as of yesterday, my boyfriend that lives with me, he got the tags renewed for the red truck and for one of the trailers, which is the boat trailer that's in the back. So those are up to date. The trailer, the double axle trailer, we use that to keep building material up off the ground.
Right.
Because as of the last time we spoke, I renovated these two homes. Their properties are side by side. The improvements that we've done to these two properties since owning them for the past 2 years is immaculate. I get compliments from the snowbird neighbors across the street. And it might not look like it in the pictures, but we were finding needles in the ground. We were finding any kind of trash. I mean, bags and bags of baby diapers in the single wide property. And it was hazardous to surrounding neighbors, in my opinion. And how much we've improved on these homes, it bothers me that the neighbors that have seen the past properties would still complain, even though they never complained about the people who lived there before. Because I asked, it was a family-owned thing, so the grandparents sold it to us, but I asked one of the grandchildren who lived there if they've ever had problems with neighbors, and they said no, and it just blows my mind how bad condition they were. So I understand I understand I have to get rid of the birds. I did not know that it was going to have to be 2 acres minimum if I wanted more than. I must have read something wrong.
So you said you own the neighboring property?
Yes, that's the 68.
Is that the one that you were here before on?
Yes, sir.
How big is that?
It's also a little quarter of an or half an acre.
Okay.
But combined, they would be an acre because they have separate tax IDs, so I wasn't able to, because I thought it was 10 birds per acre, so I was going to try to get away with that.
Well, there's ways of unifying your parcels, but I don't know that that would fix the issue either based on the testimony of the county. So how much time would you need to fix these things? I mean, you've already fixed some of it, apparently.
And that was another thing. Thank you. Originally, we also had a site for debris and junk, and we cleared that up immediately. So that was known, that was voided, like when his first initial.
So, Mr. Charlton, you'd agree that they've made progress since you began these cases?
On the junk and debris, yes.
I mean, it's gone.
You're right, I closed that case.
Okay.
And also, when he came, he said that for the lean-tos, that there was only 1 reported, and he came and witnessed 2. So he said that if I were to take pictures of the one that he thought didn't need the permit and presented it to the county, that would have been voided. But I didn't, because life happens. And
Yeah,
as
sure
I said
does.
before, had a death in the family also. So and then working in the school system, everything is closed by the time I get out.
Well, but so I guess my question is, how much time do you need to, I mean, it appears that the one that's going to take the most time is the lean-tos. I don't know, because you're already halfway there on the trailer and truck case. The animals, there's all kinds of ways, things you can do with those animals. I'm joking, but it's got to be legal. But how much time do you need to deal with the lean-to issues?
Honestly, I don't think that would be the one that takes the longest, because I take pictures and present them to the county, and that's how
I have
get a
no
permit.
idea.
Because I need 1 permit.
I don't recall ever saying that. It's what you can take them
Oh.
down, remove them from the property, and then you don't have to worry about a permit.
I mean, that's right. So
we'll say, may I have 90 days or what?
I would like to hear from the public before I issue
Yes,
an
sir.
order. But all right, let me see if I can hear from the public first.
Yes, sir.
I saw some hands of folks who wanted to talk, and if I could ask you to come up and
see, maybe.
Give me your feedback.
You can go right there.
Thank you.
Ma'am, you can stand there if you want, unless you're scared.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names for the record?
Donna Reynolds.
Daniel Rapucci.
Okay, welcome.
Thank you. Thank you. My wife and I, as well as several neighbors, are here today because of repeated code compliance issues affecting us and several neighbors by Ms. Stiegler. We've tried to deal with these issues directly with Ms. Stiegler, but she's not approachable and has taken an attitude that she can do anything with her property. I'd like to begin with just a little history that led up to the reasons for having to call code compliance on today's issues, and would hope that the special master would take this into consideration when issuing an order. Myself and my wife have 200 feet of property line that abuts Ms. Stiegler, so we've been most affected by her disregard of the county codes. Ms. Stiegler, at the last hearing involving her other property, stated she was here because of a quote-unquote neighbor issue. It's not a neighbor issue, but it's an issue in the neighborhood. Since the whole neighborhood didn't have to file a complaint, we decided that we would actually do it after getting together with our neighbors. Ms. Stiegler moved in a few years ago and was fixing up her two properties that had gotten run down by the previous owners, and we were happy to see that these properties were being fixed up. We also turned the blind eye to numerous disturbances throughout the middle of the night when she had equipment running, loud people working outside. As time progressed, there were constant loud disturbances from music. We tried dealing with the sheriff's office. The sheriff's office refused to do anything, even though they could cite, with loud music by the county ordinance. As time progressed, she began to acquire chickens, including roosters, then turkeys. They were constantly getting onto our property, and when confronted, she would just get hostile towards us. Many times, our neighbors stated they could hear her yelling at us, but they couldn't hear us. We've had to endure numerous hours of this kind of abuse of these code violations. One time last summer, we had a piece of a concrete block thrown over onto our property. Although we couldn't see on camera who threw it, we were able to tell it came from Ms. Stiegler's residence. Ms. Stiegler has also wired up a bunch of lights on the property line facing towards our property to light up our place, and her boyfriend had stated, "I'll light your place up like a baseball field." Ms. Stiegler seems to be more interested in using her resources to annoy myself and my wife as opposed to dealing with these violations. On October 26th of last year, Ms. Stiegler, during one of her episodes, put a large speaker on the property line facing the house and turned the music up so loud it could be heard blocks away. This is the incident that actually caused me to finally call code compliance and actually ask for some type of relief on the junk, the unpermitted buildings, the chickens, the roosters, and the turkeys. Our hopes are that Ms. Stiegler will come into compliance as to alleviate these neighborhood issues. I would also request that due to Ms. Stiegler's lack of these code violations, taking them seriously, that she be given a tight schedule to correct these problems. I also have a quick statement from one of my neighbors that can't be here today. They live a couple hundred feet away, and their name is Bruce and Julie Cool, and they just plainly stated they would like to see add some input on the current situation, as they live approximately 200 feet from Ms. Stiegler's residence. We cannot see the home from ours, but most certainly can hear roosters crowing at various times of the day and night, very loud music at random times, making it uncomfortable to enjoy our backyards. Bruce and Julie Cool.
Ma'am, would you like to?
Yeah, I wrote something out, but some of the items have been covered, so I'm not gonna reread what we've already gone over.
Okay.
I'll just kind of gloss over it, so if you just.
You have a right to be heard, so.
I'll read it then. It's actually probably easier for me to read it, do you mind?
I don't mind.
Okay. Everything about Tree Lay is documented with audio, video, photos, text messages, or other documents, as well as being presented under oath. This is not a neighbor dispute or a personality conflict between neighbors. This is a neighborhood problem because Ms. Stiegler chooses to publicly involve her neighbors with her negative impact her code violations are having on them. Playing a stereo loud enough to be heard loudly hundreds of feet or more away is not showing respect for boundaries or the neighbors, let alone the fact that others might want to be able to enjoy or work outside without the interference of her choice of music for the day. What Ms. Stiegler fails to understand is that her actions are aggravating more of her neighbors, not just us. Geographically, our properties are not on top of each other. Our home is 100 feet from the back property line. We have a 300-foot rear property line, 200 foot of which abuts Ms. Stiegler's 2 properties. We have a tree line buffer 60 feet sloping to 10 feet on the 100-foot property line, abutting 6901 West Arlington Place. The following sequence of events over a period of 6 months gives a few examples of the chicken problems we've had to endure. They show a consistent lack of consideration and respect on the part of Ms. Stiegler's actions that have directly affected us. Her interference in our use of our property by knowingly allowing her animals unwanted entry into our yard on a repeated and prolonged basis has been both stressful and time-consuming. It also means there have been numerous times our animals can't be in their own yard. For instance, we didn't want our dogs coming in contact with the chickens or chasing them because they were in our yard. The other day I counted 22 chickens and turkeys. That alone is more than 5 times the allowed limit of 4 hens. Included in that number are several roosters and 4 turkeys, which per the code are specifically prohibited in any number. Ms. Stiegler also continues to, and very recently added to her flock by breeding them, which is expressly prohibited. Starting around September 2022, small chickens began appearing in our yard. At various times, we let Ms. Stiegler know if her chickens are getting into our yard, she needed to secure them, giving her the benefit to do so. Beginning around mid-October, I began documenting the chickens coming into our yard because this was becoming a frequent occurrence. On November 10th, we told her she needed to keep her chickens on her property and off hours, or we would be calling animal control, hoping that might spark her into doing something. Her response was, "That's fine, and I don't mind that at all because that's the law." A couple of days later, she put a large handwritten sign on the back of her shed/chicken coop that said, "I do truly apologize for the trespassing chickens. For the record, they lay beautiful plus healthy eggs, so there you go. Merry Christmas, Happy Easter, or Thanksgiving, whatever," acknowledging she was aware that her chickens were getting onto our property. On December 7th, we noticed Ms. Stiegler put 3 cameras up monitoring her backyard. We had hoped it was to monitor her chickens so she could proactively figure out how to keep them in her yard. 3 days later, on the morning of December 10th, we noticed Ms. Stiegler detach a gate located on our property but attached to her fence. We had put this in for the previous owner's use. She did this in the middle of the night and without giving us the courtesy of letting us know. That action alone left it easier for her chickens to get into our yard. That afternoon, I had to deal with roosters and hens in the yard, and they were also digging in my potted plants. With cameras monitoring her property, Ms. Stiegler should have been easily able to see her chickens were yet again off her property due to her actions, but no one was around and she never acknowledged the incident. 2 days later, we put up a 100-foot farm fence to help keep her chickens out of our yard. On December 20th, while in the kitchen, I heard a rooster, looked out the window, and saw a black rooster in the backyard. We called animal control, and they came and got it. We relayed it most likely came from Ms. Stiegler's, the house behind us. We are not privy to what happened after that, but do know that it was eventually delivered and accepted to the animal shelter. 2 days later, on December 22nd, the same thing happened. This time there was a white rooster and a hen. I called animal control, same thing, and we don't know, it was delivered to the shelter. We were told by both the animal control officers that if the chickens were claimed and picked up at the animal shelter, there would be a $165 fine that had to be paid. So it was unlikely the owner or owners would claim them, and instead they would be adopted out. On December 28th, again, there was a small chicken on our property. Ms. Stiegler was at her fence trying to coax it back. When I confronted her, her response was, "It's not my fault, the neighbor's dogs are coming over and chasing them over." I replied, "It's not my fault either," and I reiterated, "When I find chickens on my property, I will call animal control." Shockingly, shortly after, a sheriff's deputy came to my home and accused me of stealing chickens. I told him animal control had all the info he needed and refused any further discussion on the matter. He then told me, "You'll want to talk to me when this becomes an arrest for chicken theft," which I found to be a remarkable threat, especially since I do not have a criminal record. I've never been arrested. I don't have traffic violations. I've never stolen or destroyed anybody's property, nor would I think to do so. Breath. Previous to this, I've never been accused of or investigated for committing any crime. To put things into perspective, in order to steal Ms. Stiegler's chickens, as she accused me of doing, I'd have to climb over 2 4-foot-high field fences approximately 6 inches apart. Once on her property, I would have to have chased and grabbed first a large rooster, then climb back over the fences with said rooster still in hand, then days later do the same thing with a hen. All while being monitored by at least 3 of her cameras. So did she provide that video footage to the sheriff's deputy, or did she just knowingly make a retaliatory false report to law enforcement? Ms. Stiegler waited 8 days to report the theft of her rooster and 6 days to report the theft of her hen. Coincidentally, on the same day, she is caught with yet another chicken off her property and again confronted about it. And it begs the question, why then didn't she ask around to contact animal control immediately? After being falsely accused of theft, that night we were forced to order more cameras to monitor the back property line 24/7 and stayed out of our yard for our own protection until they were installed. If we didn't begin proactively documenting the various instances of code violations early on, we very well may have found ourselves in a difficult position to have to defend. On January 5th, 2023, yet again another rooster was in our yard and animal control came and got it. Apparently this time Ms. Stiegler was home and animal control was able to verify it belonged to her because a short time later Ms. Stiegler was waving it around in front of our cameras, making some sort of statement. In all instances, we were absolutely within the law to contact the sheriff's office to report we had on our property belonging to someone else, as it's never okay to keep property that doesn't belong to you, regardless of how that property ended up in your possession. The problem hasn't abated. These code violations shouldn't be a burden to Ms. Stiegler's neighbors. She's had plenty of time to figure out how to remedy the situation, and she has known for a minimum of 3 months what the violations are. Instead, these violations have caused us to have to spend additional money to protect ourselves, animals, and property, hours of our time. We've had to endure undue stress, endure false accusations, and diminish use of our own property while trying to deal with the negative fallout and impact of Ms. Stiegler's actions and inactions in dealing with her obligations and responsibilities, showing her blatant disrespect for the process, disregard for her neighbors, an inability to own up to her own responsibilities and obligations.
Well, ma'am, I did say at the beginning that
Well,
that's all right. Well, no, what I'm gonna, that's fine. What I want to ask you to do is to refrain from making personal statements about who she is or her character.
I didn't realize that I did.
You did, and that's not relevant for what I'm here
That's
to
fine.
decide. Thank you.
I'm on my last paragraph.
Good.
While in my backyard, after the last hearing, she said, shouted over the fence line, I could have 40 chickens, and that's my right, and I pay property taxes, and you can't find my property. So I would hope you take into consideration the very negative impact that these code violations have had on numerous people for a prolonged period of time, and would request that you consider a very short window of time for Ms. Stiegler to remedy her violations so that there is the shortest period possible for a continued negative impact on us and other neighbors. And that's it. Thank you.
Thank you. All right. Is there anyone else from the public who wishes to be heard on this case? Okay. And ma'am, I will give you a chance to respond.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I
Can you
do.
please state your name?
Diane Marone.
Thank you.
I live at the corner of Westmoreland and Pershing, and it's actually across the street from Daniel and Donna, and at the corner, so I'm quite a ways away. I can just testify that I hear loud music all the way over at my place, and I do hear roosters. And that's all I can say, but it is loud enough to where I can hear it at my place.
Okay. All right,
Okay.
well, thank you.
Thank you.
Is there anyone else from the public who wishes to be heard? All right, so, ma'am, this is what's known as a quasi-judicial proceeding, and what that means is, you know, you have a right to be heard too. If there are things certainly that impact your case or that may reflect on what I decide, and I think some of that was relevant for my decision, I have to give you an opportunity also to be heard on that. So what's your perspective? Or do you have anything that you want to say about the testimony that was given?
I'll make it quick. I'm not the only person that plays music on our block. There's a neighboring that I was also touching their property. And then there's a neighbor across the street on the corner of Academy who plays music that I can hear in my bedroom. I've never once maliciously done something to target any of these people, but they have to me. And one of the events that he says was the reason why he called code on me. I was on the single wide property, unloading blocks out of my truck, stacked them up nicely. I had the music on in my truck with the windows halfway down, and it was not even all the way up, like the music volume. They will push the pushing lawnmower all the way as close to the property line as they can and turn it on and leave it running right there. And it is loud and overpowering my music. And that was, yes, when I took a speaker out and I blared it that way. But not one time have I ever done anything to target them. But they did it to target me. And there's just a lot. They go around on their golf cart and she'll be driving and he's standing up on the back looking over trying to see more code. It's very weird. I started an injunction on both of them. That's the only reason why I even had to find out their name is because I had to go, look up their address and get their name from there. Otherwise, I wouldn't have even really known their names.
Well, music's not at issue in the hearing, so I'm not taking into account what they said or what you said about the music. It's not relevant for these cases. What is relevant is the rooster, the hens.
I'm not the only people that have a rooster.
Well, but you remember this, I think, from the last hearing is it doesn't really matter if other people are violating. The reality is they complained on you, and we all have to follow the law. So,
and I understand.
I think the real issue for me is the amount of time, because I do think the testimony is useful particularly for one thing, which is that this seems to be an ongoing issue, like especially a rooster. I mean, there's a reason why the code is written, at least as that's concerned, because having roosters can really, it's kind of a nuisance.
And I totally understand that because they get on my nerves sometimes too, but I can't kill them. And I have tried to
I'm not
find
asking
homes.
you to kill them.
No, I understand.
Yeah.
And I have tried to find homes for them, and nobody wants any roosters. Right. And none of them, they are so nice. I'll pick them up. They're not aggressive at all. The only reason why my chickens ever end up on their property is because the neighbor's dog will come over and chase them. They have that on video. They'll come, and I don't have 3 cameras. I have 2. And it's not aimed at their property. They have 5 cameras aimed at my property. They'll videotape me while I'm feeding my chickens. They come around the corner of this black.
Well,
I'm sorry. That's off topic.
Yeah, I mean, so I'm pretty much ready to rule, but what I want to know is how much time you need.
90.
I mean, you've asked for 90.
What's the county's recommendation?
They don't give me a recommendation on time. They give me a recommendation on fines, but maybe they have one today. What is the county's recommendation?
County's recommendation is Citrus County Code Compliance Division respectfully requests a special master assess a fine of $100 per day for each violation, with the administrative cost to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation.
I spent $4,000 on
Just a minute.
metal framed, all enclosed, completely enclosed 4 sides and a roof to put over because we were working on the blue truck. It's a project truck. But that I have not been able to put up yet.
All right.
But I bought 3 tents, an 18 by 40.
Finish my recommendation.
Sorry.
Yeah, I'm sorry. I apologize.
We would also ask the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated in order to allow for reinspection.
Okay, thank you. This is your last chance to tell me anything that you think is relevant for the orders. That's it? All right, so I do find that the property is in violation in all three cases. I'm going to give 3 different time periods for the cases. And so in case number 2175663 regarding the animals, I'm going to give you 14 days. 14 days from today to abate the violation. It seems like that's the most pressing thing. If the violation is not brought into compliance as ordered, a penalty of $100 per day will be imposed. On the unlicensed vehicles, you've already made good progress. We're going to give 30 days from today to abate that violation. And in case number 2175664, I give 90 days. And that's on the after the fact permits. It's difficult to know how long that will take to fix. And I otherwise incorporate the standard order provisions, and that's it.
Christian?
Yeah.
You didn't say what the fine.
Oh, the fine in each case will be $100 per day if it's not brought into compliance as ordered. I'm sorry.
That's okay.
Thank you.
Thanks.
Can I get a copy of all that information?
You will get a written order.
Okay.
We'll sign written orders very soon.
Yes, sir.
Yep.
Thank you.
All right, thanks.
Next case is on the agenda. Peter Collins and Antoinette Collins. Case numbers 217-5007 and 217-5008. Code Officer Cody McGuire, signed to the case. Pages 5 and 6 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Can you please state your names for the record?
My name is Antoinette Collins.
Thank you.
Sandra Lee Trudella.
Can you spell that last name?
Licciar.
Thank you.
Dello.
Nice try, Lori. Come on.
Thank you.
I got them both here. Might as well. Yeah. They're merging.
There's 2 lots and 2 violations if you want to do them together.
I do. Yeah, I mean, that'd be great if you're okay with that.
I'm fine with that.
Okay.
Cody McGuire, Citrus County Code Compliance Officer. Case number 217-5007.
Ladies and gentlemen, thank you for coming. Go ahead.
A violation of the Citrus County Land Development Code Section 4002, site development without a development order or permit. Address 10072 West Donegal Lane, Crystal River, Florida. Property owner Peter Collins and Annette Collins. Good service via certified mail return receipt. And then I would like to authenticate the following documents and request that they may be admitted into evidence. Exhibit A, photos I took during my inspection on October 19th, 2022, and aerial photos taken from the Property Appraiser's Office website. And Exhibit B, a copy of the notice violation, copy of the notice of hearing, signed certified mail return receipt.
We're gonna do both cases, so now do the other one.
Okay. Cody McGuire, Citrus County Code Compliance Officer, case number 217-5008, a violation of the Citrus County Land Development Code Section 4002, site development without a development plan order, address 10028 West Donegal Lane, Crystal River, Florida. Property owner Peter Collins and Annette Collins, good service, signed certified mail. I would also like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during my initial inspection on October 19th, 2022, and aerial photos taken from the Property Appraiser's website. Exhibit B, a copy of the notice violation, copy of notice of hearing, signed certified return receipt.
So I think what I'm going to ask you to do is to look through these documents and let me know if you have any objection to them being evidence for either case, if that makes sense.
This is a violation. Oh, okay. Okay. And they're both the same. Oh, okay. Yeah, it's this way and then this way, I think, right? Is what they had to. On both the roads. It had to be, yeah. And we know the other ones. Thank you.
All right. Is there anyone from the public who's going to want to be heard on this case? All right, I see no response.
There's two lots. It's the two lots. These two. And they face two different roads. They have to give you pictures of both sides.
Hearing no objection, what's been proposed as Exhibits A and B in each case are evidence. Thank you.
I conducted my initial inspection on October 19th, 2022, and observed the property had numerous trees removed. While researching the property, I observed that there were no permits applied for or issued. In the aerial photos of the property appraiser summary depicts a large amount of tree cover on the property before trees were removed. I have not had contact with the property owner. As of my final inspection on February 14th, 2023, a permit has not been applied for, and that's on 10072 Donegal, West Donegal.
And is that true for both properties?
No, a permit's been applied for on the 10028.
Okay. All right. It hasn't been issued? Oh, okay. Is there anyone else from the county who wishes to testify?
No problem. Joanna Coutu, Land Development. They did apply on January 23rd for a house permit on 217508. It was denied on February 5th. The plans are kind of messed up. Basically, the site plan has a front entry garage. The building plan has a side entry garage. The plumbing riser diagram, the reviewer says no pipe sizes, no vents, not a riser diagram. The electrical load counts uploaded conflict with those on plans, which is correct. So it's not put together, so they can't approve it. But that was January 23rd and then denied on February 5th.
Okay. All right. So you've heard what the county has said. What's your perspective?
I'm the contractor.
You're the contractor,
Yeah, for
okay.
Lee Trudella Construction.
Okay.
Mainly in Marion County, we work,
Yep.
Sumter and Lake.
Nice.
Wasn't familiar with Citrus County at all, hired a permit tech to, she does some of our permits in Marion County. She said she was familiar with Citrus County. We went to work, cleared the land, had no idea you had to have a tree affidavit before, permit to
Or
clear,
site clearing
right,
permit,
before we
yeah.
did it. So yes, we're guilty. There's,
Okay.
there's no getting around that.
Yeah. So what has to be done to abate this?
If the house permit's issued and they have enough trees left or put trees on there for tree preservation, that will abate that one. The other one, there's no primary structure, so there's no plans for a primary structure that I'm aware of, so there's not really an abatement.
Are they neighboring parcels?
Yes.
Okay. What's the plan on the property?
Build a home.
On for both, like one on each, or just one home for both parcels?
They were building on lot 44. No, that's Candy, right? That's Candy's lot. You're building on lot 46, and lot 47 is behind that lot.
Okay.
Our permit tech was in the process of trying to get those lots combined for them.
Okay. I mean, is that the plan?
My both properties?
Yes.
Oh, yes.
Okay. Okay. So it's your plan to try and unify them to be one lot,
Yes.
basically, or okay.
Since this has all gone on, our permit tech has ended up in the hospital. All this stuff has been messed up. I'm trying to work it and work around it with the building department and try to get everything done.
So if they succeed in unifying the parcels, I mean, I just have to know for timing purposes.
The unification doesn't allow for site plans, it's for a building. So the Unity title won't work. They can possibly do a replat to combine the lots formally as one lot. And yeah, that would, once they're recognized as one lot and there's a house permit issued and they meet the tree standards.
replat?
Yeah,
But for 2 lots?
yes.
So on a unity of title, you said it would work for having one home on 2, like,
Right, it's for structures. It's for permit structures. It's not for uses. So the unity of title would allow them to put an accessory on that vacant lot. It wouldn't allow them to clear the vacant lot because that's not a structure that the building permit would require. So it's only gonna work for a structure over there. If they want to put a garage over there or a pool or something, unity of title could work. Otherwise, they'd have to do a replat to combine them formally, and then but that's gonna take some time. That's survey
no,
work.
replat is a horrible idea.
They're not
I mean,
that
it's just,
bad.
it takes time and money, and it's
Right,
really
it's called a
complicated.
substantially similar replat. We jump straight to final plat, so it's just one step, but it's still getting the surveys. I know surveyors are very backed up right now, at least I hear that often.
Can we also, the easement that's completely around those properties, will that be taken away as well? Like there's 7.5-foot easement between all
The substantial similar replat will not remove that easement, no. No, there's ways to get there, but that's not one of them. We can talk further after.
Okay. Well, it sounds like it won't take too much time to get the permit on the.
The house, if they clear up their plans.
Yeah,
Yeah, it was
but
an
I-
inconsistency type thing, I think,
Doesn't
mostly.
sound too hard
Yeah.
to do. I'm more concerned about the other one, so I don't think really anyone's gonna be able to give me much guidance on how long it'll take for them to abate the violation, given what's happened. So I'll make a judgment call. Is there anything else you want to share with me? I'll ask for the county's recommendation, but.
on our permitting process that we're going through, they have a tree removal after the fact that would be included on the permit? Is that just that's not a fine?
No, there's no after the fact tree removal permit. It's just that it would allow you to then have permission to remove the trees that you've already done, but we're aware of that, but yeah.
What's the county's recommendation in each case?
It's the same for both. Is that okay?
Yep.
Due to the nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assesses a one-time fine of $500 along with administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation.
So you're only asking for a one-time fine on each case?
Yes. Of $500.
And not a daily fine for. Okay, all right. I'm going to find that the property is in violation. I'll grant 180 days from today to abate the violation in each case. And I will assess a one-time fine for each violation of $500. That fine would be recorded and constitutively in the property of the owners. And I incorporate other standard order provisions.
What's the 180 days? They're paying the one-time fine,
Yeah,
so.
I mean, you're telling me there's a violation.
Right.
And you told me
Can
what
we-
it takes to abate it.
I'm not code.
Daily, one-time fine for the one that the home is being, because that'll.
The vacant one.
The vacant one, that the home that they are getting a permit for, that would be the one-time fine.
Okay.
And
You said it was the same for each case. So.
10028, and the other one would be a daily fine. But
Actually switch that.
You have the We'll switch- do I
Right,
have it
right.
backwards?
They're getting a home, and there's a matter of
Okay,
time
I now
get a
understand
home.
what you want.
Yeah.
So this is a unique situation. All right, so I'll amend the orders as follows. In case number 2175007, is that the case where the county recommends a one-time fee?
The vacant side.
Yes.
Yes.
Okay, so we'll do a one-time fee of $500 for that one. In case number 2175008, I'll give 180 days and a daily fine of $100 per day if this isn't resolved in 6 months. Okay.
permitting process.
Right, so you need to get that permit.
Good luck.
Thank you.
Next case on today's agenda, Joyce Flanagan and Kayla Ann Belcher, case number 217-7493. Code Officer Brandon Norman, page 9 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Can you please state your names?
Joyce Flanagan.
Michelle Flanagan.
Thank you.
Good morning, Brendan Norman,
morning.
Citrus County Code Compliance Officer. This is case number 217-7493, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 8341 South Lake, Consuela Drive, Floral City, Florida, 34436. The property owner is listed as Flanagan Joyce and Belcher Kayla Ann. I have good service via certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A is going to be photos taken during the initial inspection on December 5th, 2022, and my corrective action inspection on December 29th, 2022, and photos of my final inspection on February 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed and certified mail return receipt.
All right. Ma'ams, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence in this hearing.
That guy's coming to get today.
Yeah.
Yeah.
Yes.
No objection to these?
No.
No.
Okay. Is there anyone from the public who wants to be heard on this case? Okay, thanks. Without objection, what's been proposed as exhibits A and B are evidence.
On December 5th, 2022, an initial inspection was conducted at the property for junk and debris. The property was found to be in violation of the above ordinance. The property remained in violation at my notice of violation corrective action inspection on December 29th, 2022, as well as my pre-hearing inspection conducted February 14th, 2023. I have had contact with the property owners, and they are aware of the violations that are present per our conversations.
Well, what's going on?
That's accumulation of a lot of junk. I know we're working on it. I have a dumpster. We've gotten a dumpster. A lot of that is gone. The one stuff in the last picture that he took yesterday. There is a guy coming this afternoon or first thing in the morning to take care of it, to get all that stuff out. There's like 100% improvement in the stuff in the back. All that tarp is gone and all that stuff is clear. There's a few more things that needs to be done.
We're working on it.
We're working on it. We're doing good. I just need a little bit more time to finish it up.
I just want to make sure you know all that stuff that's kind of just out in the, even though it's under the overhang, a lot of it might qualify under this case. So it's just got to be tough decisions.
That's what I'm saying. We have the dumpster.
No, I see. Yeah.
And
Okay.
some of it is also for when we go to redo our bathroom, but we can't put it in the house to leave it in the house to sit. You know what I'm saying? It's
Well, you might have to.
well, then we won't
Because it
have
can't
room
be
to
there.
move.
Well, unless, so you're saying some of it is going to be used for a
Yes,
project.
there's plywood, there's a bathtub,
Okay.
there's a toilet, all to be, once we get the money to be able to redo the whole bathroom and get, everything else. That's sitting outside. That just got moved and put off to the back, and there's
So
other
Norman, are you
stuff.
aware of that, or would that qualify as something that they're able to keep under the overhang?
I was not aware of the renovation portion. I believe
If
that
it
we,
is.
I believe that we would be okay with it as long as it's neatly organized and it's in a manner that doesn't appear to be like junk and debris.
Okay. It is. I can't show you my phone, but I have pictures I can show you if you want to see of where it's stacked.
You know, I think
over
this is
here.
okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of this violation. This amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been evaded in order to allow for reinspection.
Can you get this? I mean, it looks like you have made progress. I mean, is 30 days enough time to get it to the finish line?
Can I have just a little bit more time because she's disabled and can't help me and I have to wait for my other grandchildren on their days off. So we can do it.
All right, I'll find that the property's in violation and grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. I otherwise incorporate standard order provisions.
Thank
you.
Thank you, sir.
Yep.
Next case on today's agenda, Christian Roos, case number 217-3472, Code Officer Cody McGuire, page 19 of your agenda. Expert on the case, Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Please state your name for the record.
Christian Rousset.
Good morning.
Morning.
It's Rousset?
Rousset.
It's all good.
All right, Cody McGuire, Citrus County Code Compliance Officer, case number 217-3472, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit, address 8664 West Rue des Prairies Place, property owner Christian Rousset. Good service, signed certified mail. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos I took during the inspection on September 23, 2022, and aerial photos taken from the property appraiser's website. And Exhibit B, a copy of the notice of violation, copy of notice of hearing, signed certified mail return receipt.
All right, sir, I'd like to ask you to take a look through these documents and let me know if you have any objection to them being evidence.
No objection, sir.
Thanks. Is there anyone from the public who's going to want to be heard on this case? Okay. Okay, with no objection, what's been proposed as exhibits A and B are evidence. Please proceed.
I conducted my initial inspection on September 23rd, 2022, and observed that the property had numerous trees removed. While researching the property, I observed that there were no permits applied for or issued, and the aerial photo of the property appraiser's summary depicts a large amount of tree cover of the property before trees were removed. I have had contact with the property owner. As of my final inspection on February 14th, 2023, a permit has been applied for a preconditional use.
Before I get to Mr. Rousset, what is the county? I'm interested in what the county wants in this case. Like, what does it recommend? What does the county recommend?
500.
It's going to be a one-time fee recommendation?
Yes, 500.
Okay, that's what I was curious about. Mr. Rousset, what's going on?
Yeah, I just purchased the property back in August. You know, my game plan was this is my retirement. Eventually, I'll build something, but it's not going to be happening soon. I did try to do a conventional use because my ultimate goal was to put a structure and fence it. But I guess neighbors aren't not liking the idea, so I'm like, that's not gonna be approved anyway. So
You never know.
Well, I mean, it's 2 hydroponic structures farm because I'm an agriculture officer. So my game plan is eventually that's going to be my retirement gig.
Okay.
The conditions of the committee saying it has to be in a short period. I think it's 3 years. I don't want to close 3 years to comply with that permit. I'm not going to do it in 3 years.
Okay. Is there anyone else who wants to testify from the county?
Unless you need it, doesn't sound like you're going to.
I don't. I know what the county's recommendation is. I think it's fairly simple. All right, I will find that the property's in violation, and I will simply assess a one-time fine of $500. And I'll incorporate the various standard order provisions, and we'll issue a written order.
Sounds good.
All right, thank you.
Thank you.
Next case on the day's agenda, Linda Marion Thrush, case number 217-9102, Code Officer Brandon Norman, page 26 of your agenda. Expert on the case, Joanna Coutu.
Good morning. Brandon Norman, Citrus County. I didn't realize she was here. I did a pan.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, ma'am. And can you please state your name?
Linda Marion Thrush.
Thank you.
Okay. Good morning. Brandon
morning.
Norman, Citrus County Code Compliance Officer. This is case number 217-9102, special requirements for all accessory structures, a violation of Citrus County Land Development Code Section 3102A. The address is 4268 South Arrowhead Drive, Homosassa, Florida, 34446. The property owner is Thrush Linda Marion. I have good service via posted to the property in the Lecanto Government Building. I would like to authenticate the following documents and request that be admitted into evidence. Exhibit A is photos taken during the initial inspection on January 3rd, 2023, and the corrective action inspection on January 19th, 2023, and photos at my final inspection on February 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, and a copy of the posting affidavit I completed, as well as a photo of the posted notice of hearing at the property.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. Any objection, ma'am?
No.
All right. Is there anyone from the public who wants to be heard on this case? Okay. Ma'am, what's the pin on your hat? I'm just curious. There's a...
Oh, that's Republican Party.
Oh, okay. Like national or state or local?
Trump.
Oh, okay, gotcha.
Sorry.
You don't have to apologize. You're allowed to express whatever.
Yeah.
You have First Amendment rights.
Yeah.
I just didn't know. I couldn't see it from here
I know it's a little somehow I got it in the mail and I thought it was very unusual.
Yeah.
And so I read that, and then I have Cigna's over here probably for Alzheimer's for my mother.
Oh, wow. Without objection, what's been proposed as Exhibits A and B are evidence.
On January 3rd, 2023, an initial inspection was conducted of the property for multiple trucks and trailers on a vacant lot. The property was found to be in violation of the above ordinance. The property remained in violation at my notice of violation corrective action inspection on January 19th, 2023, as well as my pre-hearing inspection conducted February 14th, 2023. I have had contact with the property owner, and we've discussed the violations.
You have enough stuff here to start a new A team, you know, with
No.
Mr. T. I'm impressed. All you need is a helicopter.
Yeah, that's true. Yeah, no.
Is,
The Peterbilt is the semi, which a lot of people have. I mean, I have pictures of other people having semis, but it's hard to find a place to put it. I haven't lived here that long to know, and I think we have finally found a place, but it is going to be sold because my husband cannot drive it anymore because he has a very serious bad condition. So it is going to be removed from the business and made private eventually, but it will be off the property. The other truck is my private truck, and then we just have some boat trailers. But I have incorporated the parcel of land for unity of title. So now I have one parcel with the structure, and I'm moving a shed, and I just applied for the building permit to put my shed on that property also. And then we also gonna get, we're very busy, a pole barn, and then that we can kind of neatly put some things there, and then that's clean it up, and that's that.
Have you already succeeded in getting unity of title for this property?
Yes,
Oh, you
it's
have.
been done.
This is
Yes.
why I should have asked if the county had any other witnesses.
Yeah, it's been done.
Okay.
Yeah. It's the property appraiser has it, and it's been done.
Right. There is no unity of title to date or permits to date. I know you said you applied for a shed permit. Was that recently?
I went yesterday, the day
Okay.
before Monday.
Okay. It's not in the it's not in the system yet.
No, not yet.
A unity of title could allow a shed there. It's this medium density residential. Joanna Couture Land Development. Medium density residential. The primary structure was removed in 2019 with a demo permit. So there has not been a primary structure since then. The unity of title could allow a shed. It's not going to allow trucks at all. The acreage is too small. It's 0.65, and they would need a conditional use and 5 acres. So trucks are not at all going to happen.
That's not going to happen.
Right.
Okay.
I have three acres now. Under
It's
the
still not enough.
Under the unity of
Based
title.
on what? Yeah, I think.
It's per lot on trucks anyway, and a conditional use and 5 acres.
But I mean, in best case scenario, you would need 5 acres.
Right.
And so it's not enough. So basically, what I would need to know from you is how much time you need to either establish a principal use on the property or to get everything off.
No, the land development had told me once I put the shed there, I could certainly have my boats and trailers there and then my truck.
Well,
So
do you
I'm-
distinguish between boats, trailers, and trucks?
The semi is going. The only one I have
Okay.
is the one red truck.
Yeah,
That's
the
only-
trucks are concerning. I'm not sure what size trucks we're talking about. If we're talking about the ones we regulate as trucks or storage. She does the unity of title for a shed on the second parcel. Then she can use it as development, so she can put other things there, provided, we don't go in the junkyard and everything has a permit. Yes.
Oh, okay. All right.
Yeah.
So but that assumes unity of title. All right. So then what I need to know is how much time do you need to finish the unity of title process and remove the offending trucks, basically? Because what they're saying is you have not completed the unity of title process.
The county, I went and recorded it and I asked her and she
When did you record it?
It was, I left the file at home.
But it was approved by county
No, we don't approve them. It's part of a permit issuance. So the permit issuance would recognize the unity of title. Yes, the requirement is that they have it that in hand and give it to us, but it's not unity until we have the permit issued, and that's what the unity of title works for. So until the permit's issued, it's not, it might be a piece of paper, but it's not doing anything because there's nothing to tie together.
What permit?
Well, there's a
The
permit.
shed permit that you said you
Oh,
applied for?
I did, yeah, I did.
Yeah,
I did
it's a
that
shed
on
permit.
Monday.
Okay, that makes sense.
That I've done.
All right,
Yes,
I'm
but
on
the
the same
unity of
page.
title I did before
Okay.
I went.
How much
Yes.
time do you need to get rid of the trucks that you are not allowed to keep there?
I don't know where to go. I wish I knew. I mean, the semi is going. We finally found a person we could put the semi on.
Mhm.
But the I have other trucks also. I have a white Ford truck. I can't have a truck on my property. It's on the parcel of land that I have. I have 3 acres now under that parcel of Unity.
I mean, you
So-
can park tagged vehicles. No one's saying that. It's semis, and you only have
Well,
the
the
one
I said
semi.
it will be, finally found a place for
Okay,
the semi.
so if that's the only vehicle at issue, how much time will it take you to get rid of this?
Well, we should be doing it within a period of time, maybe a week or so. I don't want to say exactly, but it looks like it would be, we definitely wanted to get it off the premise.
Okay.
Yeah, that's my goal. It's been very difficult to say. I've only been here a short period of time. I don't even know half the roads and the streets. And we did make phone calls, and it was very difficult. Through a neighbor, we found somebody who will take it in for the time being. And then we're removing the business name so that it just becomes a truck.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given the severity of the violation and the respondent's action relative to this violation. We would also ask the special master to additionally find its respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. I will adopt the county's proposed findings of fact. I will grant 60 days from today to abate the violation. I'm giving 60 for 2 reasons. One is that I just am a little uncertain that the unity of title process, I think it sounds like all you'll need to do is pull the permit, but sometimes there's issues with that. So you may need more time.
Well, there wasn't when I went to the county.
And so you're getting a little extra time for that. And then just in case something falls through with the truck.
Yeah, I have a question though.
One moment. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed, and then I'll otherwise incorporate the other order provisions.
How come you can tag and title that particular vehicle not knowing it's not allowed? Because, I mean, like, you could have them for evidence, I don't care. There are gobs of semi-trailers in this area.
I don't know what you're talking about.
Well, I got a tag and a title, so it was legal, but now it's not legal, in a way.
Who says it's not legal?
Well, they said I can't park it there.
You're not allowed to have certain vehicles in
Well, that's
certain
what I'm-
places.
But
The state regulation of titling is totally.
But how do you know when you come new into the area, there's no, and I tried to find them to read.
Well, because, ma'am, this is, you need to learn everything that's in this
I'll thank you
land
very
development.
much.
Here it is.
I already worked for 60
is.
years. I don't want to work anymore. 75.
Then you can pay your friendly local real estate lawyer some money to read it for you.
I don't know anybody. So,
yeah.
but I mean, but these people are allowed, is what I'm saying.
I don't know the answer to that. And you know, you may have heard some other folks bring it up in this hearing, but a lot of people say, well, gosh, I'm being hit up with this, but look at the property down the street. Look at the property around the block. The problem is no one's complained about them, you know? So it requires a complaint.
Oh, so in other words, you have to rat on somebody.
You have to rat.
Yeah, I can't rat. I mean, these people are working.
All
they're
these cases
hardworking.
come from rats.
Yeah.
But they have good concerns a lot of times. You know, sometimes there's really health and sanitary concerns. Sometimes the structures are unsafe. We could argue about the morality of it, but that's how it works.
Well, we were just trying to make a living, but that didn't work out. very seriously bad back. In fact, he had to go out. He can't sit very long.
Well, I appreciate it, ma'am. I mean, I think we've made clear what has to be done, and so I'm gonna close this
So,
one, and it's over.
So when the semi is out of there, I tell him, I call him. up
I'd
and
stay
tell
in
him-
close contact with the county about this.
And then the
And the shed permit.
well, the shed permit.
Yeah, the shed permit's really important as part of this.
Lynette handled it for us over there in permitting,
Okay.
and she said they would call us. All the papers are in.
Well, ma'am, the hearing's over, and I encourage you to contact the county with any questions you might have.
Thank you, sir.
Next case on the agenda, Edward and Erica Connery, case number 217-2846, Code Officer J.C. Charlton, page 7 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. And your name?
Edward Connery.
Thank you.
Good morning.
Morning.
J.C. Charlton, Citrus County Code Compliance Officer. This is case number 217-2846, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 7281 West Village Drive, Homosassa, Florida. Property owners Edward and Erica Connery. Good service via signed certified mail return receipt. I would like to authenticate the following documents and request to be admitted into evidence. Exhibit A, photos taken during an initial inspection on September 13th of 2022. Corrective action inspection on January 12th of 23, and my final inspection on February 14th of 2023. Exhibit B, notice of violation, notice of hearing, and a copy of the signed certified mail return receipt.
Sir, would you mind taking a look at these documents and letting me know if you have any objections to them being evidence?
It's all falling apart. They don't like to work properly. Oh, this is the court date? Okay. Yeah, okay.
No objection?
No objections.
All right. Without objection, what's been proposed as Exhibits A and B are evidence. Is there anyone from the public who's going to want to be heard on this case? All right, I see no response.
An initial inspection was conducted on September 13th, 2022, and photos depict the property be in violation of the ordinance listed above. As of this week, I had no contact with the property owner. He contacted me Monday, and good progress has been made on the junk and debris that was on the property. However, my final inspection on February 14th, 2023, property remains in violation with some discarded items, construction materials, and some debris on a trailer on the property.
Huge progress, I'd say. All right, so what's going on?
Well, apparently I got a certified letter in September, but unless you catch my roommate home on her day off, I don't get anything certified. It goes back to the post office, but I work 7 days a week.
Okay.
I work a full-time job and own my own business. So by the time I got to the post office, with the thing, they had already sent the thing back. She was home when they sent the other mail. I called up to the code office. They verified everything, and then I started working on the progress. And then Monday I called and got a hold of him and found out what our further procedures were.
Okay.
I did clear up 2 of the violations. I just need more time. I ended up getting a storage unit for a lot of my building supplies because, like I said, I own my own business too. So I had a bunch of building supplies sitting there, and the trailer is loaded up because it's going to the dump on Saturday because it's the only day I have to go down to the dumps and scrap yards.
Well, I mean, honestly, it does look like huge progress has been made. How much time do you need to get it to the finish line?
Probably about 3 months.
3 months? I mean, doesn't look that bad.
Well,
I know how much you work.
That shed in the back has to be tore down completely.
Is that a part of another case?
It's not, but it needs to be.
Okay.
It needs to be.
Well, that isn't really a part of this case, though. Getting the junk and debris off the property is.
Yeah. The limit is only being able to go to the dump once a week.
Right.
That's my limit.
Right.
And that's why I said, 3 months, because even, I take a load to the dump and then I still go back to work after I'm done with that. So.
Are there any health sanitary issues?
No.
That you know of?
Not that I know of.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests a special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were aware of the violation. We would also ask the special master additionally find that it is respondent's responsibility to contact the Code Compliance Division when this violation has abated in order to allow for reinspection.
Okay. I adopt the county's proposed findings of fact. I'll grant 90 days from today to abate the violation, and if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed. I otherwise incorporate standard order provisions. All right.
Thank you.
Thanks.
Thank you. Next case on today's agenda, Mike Floyd and Kathy Foy, case number 217-7195, Code Officer Alan Jonason assigned to the case, page 10 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, sir?
Michael Foy.
Thank you.
Good morning. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2177195. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 4664 North Canoe Terrace, Hernando, Florida. Property owners are Foy Mike and Foy Kathy. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 28 November 2022, photos from a compliance inspection on 28 December 2022, and photos of my final inspection conducted on 14 February 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the continuation letter that we sent last month, and a copy of the signed certified mail receipt for the continuation letter.
Sir, I'd like to ask you to take a look at these documents. You know the routine.
We're good.
Is there anyone from the public who wishes to be heard on this case? Okay. No response. Thank you. Without objection, what's been proposed as Exhibits A and B are evidence.
On 28 November 2022, I conducted my initial inspection and observed the property to be in violation. On 28 November 2022, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 28 December 2022, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, but as of my final inspection on 14 February 2023, their property remains in violation.
Okay. Sir, what's going on?
Bought the house November, a year ago. My brother died in January. I'm from Maryland, so I went back home. Yesterday was the first day I've been here since, it's been a year. Anyway, when I bought the house,
Okay.
November, it had, the refrigerator was nasty. We took it out, put it beside the porch. We have a parrot. We put the cages for the parrot.
Wow.
We brought him down when we came in and I flew back home. So it's a one vehicle. The car, which I don't even think it's an issue now, right?
The
Anyway,
vehicles are not an
there was a
issue.
car there that was, I bought with the property. It's a title issue because the guy died, so we're waiting for the title. The truck in the driveway was mine. I drove it down there, but I flew home when my brother passed, so that one just expired. So I'm gonna renew that one here.
Well, you
Yeah,
know,
but
be careful.
But the vehicles
Be
are not an
careful.
issue.
Yeah, they're not issues.
All we're here to talk about
Okay.
is the discarded furniture, kind of garbage.
Well, it was
in
a
the yard,
refrigerator.
and also junk and debris.
Yeah, right. Anyway, that was, when he was there yesterday, there was there was a tank in the front yard when I got the house. We got rid of that. The refrigerator I took out of the house because it was nasty, but I had somebody remove that. The washer and dryer my neighbor gave me, that was by the back door, but I never got a chance to put it in, so I just got rid of them too. And then the parrot cage we put inside.
Yeah, so things that
So I think that's
go inside ultimately cannot be used
right.
against you.
But I didn't know I was going to go to Maryland for a year either. You know what I mean?
Right.
So
Well, how much time will it take you to finish the job of cleaning everything up?
we pretty much did it yesterday. I mean, yeah, I got down here Monday night.
Okay.
Yesterday I worked my tail off.
So,
So I mean, he could come back. I guess. Well, I got to go back
30
home.
days is enough?
What's that?
30 days
Yeah,
is
30
more
days,
than
yeah,
enough?
yeah.
Okay.
Yep.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. I'll grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day would be assessed. And I otherwise incorporate standard order provisions.
Thank you.
All right.
Next case on today's agenda, Gilbert A. and Charisse Nair, case number 217-8296. Code Officer Alan Jonathan, page 17 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Yes. Can you please state your names?
Charisse Nair.
Gilbert Nair. Thank you.
Good morning.
Morning.
Sorry, I had to get my notes straight. Alan Jonathan, Citrus County Code Compliance Officer. This is case number 217-8296, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances.
The case I have is different. It's a 20-41 unlicensed, unserviceable, or inoperable vehicles.
That's what I apologize.
Okay.
Oh, my goodness.
You know, I stopped drinking coffee 2 weeks ago. 2 weeks ago, I did. I have a love-hate relationship with this thing, and boy, I'm dragging myself.
This
So you
is for
know,
unlicensed vehicles. My humble apologies.
I'll survive.
The address is 4526 East Avocet Court, Inverness, Florida. Property owners are near, did I say that right? I hope I did, near Gilbert and near Charisse. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during an initial inspection on 14 December 2022, photos from a compliance inspection on 17 January 2023, and photos of my final inspection conducted on 14 February 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail receipt.
Okay. Well, you've been here long enough to see the routine. I just want to know if you have any objections to these documents.
No.
Is there anyone from the public who's going to want to be heard on this case? Okay. Let the record reflect there's no response.
I'm gonna do him.
Without objection, what's been proposed as Exhibits A and B are evidence.
On 14 December 2022, I conducted my initial inspection and observed the property to be in violation. On 14 December 2022, a notice of violation was issued for unlicensed and operable vehicles, which is a violation of the ordinance that I didn't list above, but is from unlicensed vehicles. On 17 January 2023, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner, and as of my final inspection on 14 February 2023, the property remains in violation.
So what's going on?
I have it all registered and insured as of yesterday.
Okay. I don't think it would be wise to attempt to introduce that in evidence. Sounds like you would need that.
Yes, yes.
Would you mind showing it to Mr.
Absolutely.
Jonason?
Yep.
And
That is for the Camaro. And that's the insurance.
a lot of dreams have lived and died in that Camaro.
That's
Been through a lot.
pickup. And then the trailer is. It's this one right there, the GX. I do, I just don't know where it is. I'm gonna put the license plate on it, yeah.
all right.
Yeah.
Okay. What I'm gonna do is, it sounds like you probably have mostly complied. There's technically maybe not enough for the county to dismiss the case without being shown the tags on the cars.
Okay.
So I am gonna issue an order on it, but it sounds like it's gonna go away pretty
Yes,
quick.
sir.
Yeah.
Okay. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative cost to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for
I
reinspection.
hate to give y'all more work. It's just for the evidentiary record. I guess just you're gonna have to go out there and verify. All right.
Yes, sir.
So I will find that as a technical matter, the property is in violation and grant 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a fine of $50 per day. But
Okay.
it's over. Thanks.
Thank you.
Okay, thank you.
Next two cases on the agenda, Raymond L. Murray, case numbers 217-8308 and 217-8311. Code Officer Brandon Norman, pages 15 and 16 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
And your name, please.
Raymond Murray.
Thank you.
Morning.
Good morning.
Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-8308, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, as well as case 217-8311, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 2041 of the Citrus County Code of Ordinances. This address is 5740 South Ocelot Point, Homosassa, Florida 34446. Property owner listed as Murray Raymond L. I have good service via certified mail return receipt for both. I would like to authenticate the following documents and request they be admitted to evidence. These photos that I'm about to talk about are different photos, but all taken on the same day.
Okay, thanks.
Photos taken during the initial inspection on December 13th, 2022, and corrective action inspection on January 19th, 2023, and photos of my final inspection on February 14th, 2022. Exhibit B, again, different notices of violations and notices of hearing. A copy of the notice of violation, a copy of the notice of hearing, and a copy of the signed certified mail return receipt for both cases.
Sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Most definitely. Wow, that did look bad. Okay. These are good pictures.
I like to moonlight.
You know, there's a craft to code enforcement, and the quality of the photos, you know, factors in. So.
Heck yeah. Yeah.
Okay. Any objections, sir?
None.
All right. Thank you. Okay, gotcha. Without objection, what's been proposed as Exhibits A and B in each case are evidence.
On December 13th, 2022, an initial inspection was conducted of the property for junk and debris and unlicensed and inoperable vehicles. The property was found to be in violation of both of the above ordinances talked about above. The property remained in violation of my notice of violation corrective action inspection on January 19th, 2023, as well as my pre-hearing inspection conducted February 14th, 2022. I was able to make contact with the property owner during my initial inspection and explain to him on how to abate these violations. Since then, there has been some progress made, but there's still some areas of concern.
So how many vehicles are at issue here?
At the current time, for my inspection done yesterday, I observed 2 vehicles and 1 trailer.
Okay. Because there's looked like a lot of different vehicles
Oh, yeah,
over
there
time.
definitely was. And
Yeah.
yesterday there was probably 6 more in my yard, but
Wow.
they were all friends. And,
I gotcha.
which one is still the concern?
At this time for my inspection yesterday, it's the orange pickup truck. It appears that it's missing windows and
The
suffered some
orange
serious
pickup truck
serious
was
damage.
in, there was an accident like 2 weeks ago, and it caught fire while I
Okay.
was sleeping.
Yeah.
Insurance is actually coming for that in the next few days.
Okay.
How did it catch fire while you were sleeping?
Ignition switch, something electrical shorted out.
And then the gold sedan. I believe
The
it's
gold
a Jaguar.
sedan, the Jaguar.
I believe it's a Jaguar.
That it is tagged.
Mhm.
That car belongs to a friend of mine, and he's back in New Hampshire until April or May.
I mean, it doesn't look, I mean, it looks like it's got some problems.
It actually, I can start it up and move it around. It's just been sitting, so.
Okay. What else? What's the other one?
The camper trailer that is in the rear of the property, it looks like it might have flat tires. From what I could see, it appeared that they were flat, so.
Yeah.
That would make it inoperable for us, so.
Okay. Yeah, I don't think they're flat, but I'll double check.
Yeah, that
because
doesn't.
That's actually just getting moved to the
Okay.
back corner of the property for now, where the old green truck used to be parked. And basically, the only thing that's really left there as far as debris, I got most of that concrete pad done yesterday, and there's just a couple pieces there where I'm gonna have like outdoor patio furniture sitting up in that corner. The doors that are sitting on the front side of the mobile, and I've got like 2 loads of scrap.
How much time do you need to fix the junk debris issue?
Monday, Tuesday,
Okay.
just a few days.
Okay.
I've got a lot done in the last couple days, honestly.
It's difficult to see the trailer, so but how much time will you need to fix the at least one inoperable vehicle issue? Which means you can either.
If you could give me 30, I don't think it'd take that long.
I mean,
because I've got it
okay.
planned on being moved in a couple of weeks.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day per violation, along with administrative costs to begin after the date that you deem sufficient to abate these violations. This amount was selected based on the actions of the property owners once they were advised of the violations. This amount is appropriate given the severity of the violations and the respondent's actions relative to these violations. We would also ask the special master additionally to find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Okay. What I'll do is I'll find that the property is in violation in each case, and that I'll grant 30 days from today to abate each violation. And if the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed, and that's true for each case. All right. Otherwise, I incorporate the other standard order provisions, and we're done.
Okay.
Thank you, sir.
Thank you.
Next case on today's agenda, Tiffany M. and Warren J. Mao, case number 217-7995, Code Officer Brandon Norman, page 14 of your agenda. Expert on the case, Joanna Coutu.
Hello again, Brandon Norman, Citrus County Code Compliance Officer. This is case number 217-7995, special requirements for all accessory structures, a violation of Citrus County Land Development Code, section 3102A. The address is 9294 South Spoonbill Avenue in Floral City, Florida, 34436. The property owner listed is Mao Tiffany M. and Mao Warren J. II. I have good service via posting at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on December 7th, 2022, and the corrective action inspection on January 11th, 2023, and photos of my final inspection on February 14th, 2023. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit I completed, and a photo of the posting of the notice of hearing at the property.
Okay. Is there anyone from the public who wishes to be heard on this case? Let the record reflect there is no response. Okay. Sure. Just put it on. I don't know if the mic can pick you up, so it's important. If you want, you can just.
So it's an overturned RV that's located on the property. I've highlighted it here. That's out of yesterday, and you can barely see it here as well, so I highlighted it. Yep.
Gotcha. All right. There's been no objection to the exhibits, so they're now evidence.
On December 7th, 2022, an initial inspection was conducted of the property for an RV on a vacant lot. The property was found to be in violation of the above ordinance. The property remained in violation at my notice of violation corrective action inspection on January 11th, 2023, as well as my pre-hearing inspection conducted February 14th, 2023. I have been unable to make contact with the property owners as of today.
Okay.
It appears that it's been there for quite some time.
Yeah. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. This amount is appropriate given that the severity of the violation and the respondent's actions are relative to this violation. We would also ask the special master to additionally find it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
You said $50?
Yes, sir. Mm-hmm. I'm still actively trying to do a little bit of extra research and see if I can track them down. The address that's listed on the property appraiser's website is to an Air Force base. So I imagine this is an out-of-state person who purchased the property and they're probably unaware of it. So I'm doing my best right now to see if I can track them down and make them aware of them.
That's good.
It just looks like it's been there for a very, very long time. It doesn't look like anything's, it's something recent, so.
All right, well, based on what you represented, I'll find that the property is in violation and I'll grant 60 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed.
Thank you.
All right.
Next case on today's agenda, Stephen Jagir. Case number 217-6854, Code Officer Alan Jonason, page 12 of your agenda.
Oh, okay.
You asked us to brief the case out of Mount Dora, so I did a memorandum that shows basically what happened at the code hearing, and then
Oh, wow.
An appeal was filed but dismissed, and a federal court case was filed but dismissed. So that's what I have. The special master's decision.
Okay. Well, I sure would like to read it, if possible.
It's pretty brief.
All right, I'll glance at it.
This is just the other
If
decisions, because there was initially the code hearing and the special master's decision.
I don't know, on the weight test.
And then, then there was a second hearing where they did the fine order, and a third hearing where somebody asked for something else, so.
Okay, if you don't mind, I might be able to get through it real quick. Let me just take a look. Well, I think it's awesome, but I just respectfully need a little time to look at it before I can issue a ruling. So I'm going to continue this to the next
There
hearing.
are people from the community.
Oh, wow.
That's
Is
why.
there someone from the public?
Yes.
Well, absolutely. Well, hey.
There's people here.
Yeah, I was wondering what y'all were here for, and I certainly do want to hear from you. So. You're probably fans of the art, right?
Very much so.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name, please.
Barbara Larimer.
Thank you.
Thank you, Ms. Larimer. I'd love to hear from you and whatever you have to offer.
Well, as I say, he's got the pictures of what is going on across the street from us. It's getting worse. I think he thinks it's art because of everything he brings out. and nothing gets put away. And my son and I are just tired of looking at this. And somebody needs to do something about it. Because it's just junk that he brings out in the front. We're in a neighborhood where people go by, they slow down, they turn around, they go back and look again. And I think he thinks that's all art, and he thinks that, looks good. So that's why I contacted the lady to see what could be done about it. He has 3 vehicles back there.
Yeah.
He's not worked on them. He has no license, no insurance. The one van that's to the west, he can move, but the other 2 that I know of, the car is not movable. It's not running.
There's a dilemma for me from a legal perspective, and the dilemma is that on one hand, if all anyone ever had to do with junk in their yard is put a sign on it or spray paint it or put some paint on it with a message that somehow that acquires protection, then that would obliterate code enforcement, I think. On the other hand, there's a case that I wanted some briefing on that is it's not the same, but it's somewhat related in my mind, where Mount Dora frankly got in some trouble because they attempted to, well, I'm not an expert in the case. I guess Ms. Antrim.
I can summarize it.
Yeah, summarize if you don't mind.
It's very brief.
Yeah.
In that case, there was the homeowners had a house, and then there are 2 sides of the property were surrounded by a wall. They hired a painter to paint a graphic design, that's how it was termed in the decision, on the wall, and the painter also put his sign up next to it. Some neighbors complained, or people complained, and citations were issued for graffiti and a commercial sign in a residential district violation. The graffiti violation was later dropped. They proceeded to hearing. By the time of the hearing, both walls had been painted and the house was being painted with the same graphic design. At the hearing, the special master determined that violated the sign ordinance because it was, their sign ordinance was very broad in what was defined as a sign. And since this graphic design attracted the attention of people driving on the road, the magistrate determined that the county or the city had the right to regulate it for purposes of public safety. That decision was final. A fine was issued. An appeal was filed. However, the appeal was dismissed, so that decision still stands. And the federal court action was, there was a stipulation and an order of dismissal. There was nothing in the stipulation that indicated that the city had come off the decision, although probably they had come off to some extent. But the mural's still there, the sign is still there, not the painter sign. That sign was removed. But that's how it stood. So really, since it's a code case and it's from it's not even from a county, it's from a city. It is within our Fifth Circuit. However, it was never determined by a court.
There's no appellate review of it whatsoever.
Right, so I don't believe it serves as precedent in this case at all. And if it did, it would support a code violation.
Unless there are some good briefs on the subject from the owner, I don't know if it was the Institute for Justice that was behind it, but my
there was a memorandum of law. There was other things
amicus
filed
briefs
in the federal case.
Yeah.
But there was never a ruling.
Well, no, I know, but they may have pointed to dispositive cases, which is what I'm concerned about. In other words, it may have been that Mount Dora exposed itself. I just don't know. And so that's what I want to look at, and that's why I'm not issuing a ruling today.
I think the main problem with the Mount Dora case was the problem with issuing a violation for signs. Because the Supreme Court, I think after that time or shortly before, had the U.S. Supreme Court, a big ruling on sign ordinances.
Yeah.
here. But we're not here on a sign
I agree.
ordinance. We're here on trash and debris. And
It looks like trash and debris to me, but I want to be right. And I think that there are at least one or two potential issues that I don't feel like I have answers for, legally speaking. I suspect that what I said earlier is right, that this is just a case where it's truly junk and debris, and even if it has some kind of artistic merit to somebody, that it's still subject to regulation as suggested by the county, and that I should issue an order finding it. And I don't think the owner's ever appeared to defend himself.
He has no way of driving
Oh, really?
unless he brings somebody with, somebody picks him up.
Yeah, and look, I do want to hear from everybody, so if you don't mind, yeah.
Do you swear to tell the truth?
His other hand also.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And both of your names?
Rebecca Workman.
I'm David Lerman.
Thank you.
Miss Workman, is it?
Yes.
If you don't mind speaking into the microphone, just to make sure we pick it all up.
I moved in, I live next to her, across the street, catty corner from Stephen Shiger, and directly across the worst one as far as too many other things, across the street next to him, where I got involved trying to be a good neighbor.
That's right. No good deed, man.
With Stephen Shiger, I got involved, I think it was about 2013, 14, when Roy Boy Gertz, the one directly across from me, that mental health issue, moved in the spring of 2012, 13, one or the other. Helped him move in, helped get his stuff from another place. Ended up him and Steve both having similar mental health issues, from my knowledge of the two of them. Got into a clash, and in both my mother's and my opinion, Stephen Shiger ended up in jail for about a year or so. Roy Boy was the actual, the other neighbor was the actual provocateur and instigator. Anyway, during that year, he was constantly a verbal battle between her husband and Stephen.
Okay.
When I came into the picture, found that just kind of keeping in touch with him kind of helped keep on his meds and so on and so forth. That year in jail, to try to help him, I myself went out and cleaned his yard and mowed it and shuffled and hauled and whatever.
So, yeah.
With a little bit of help of her husband and son at the end of it. But Stephen Shiger is extremely boisterous. He'll scream, yell, profanity, whatever, doesn't make any sense. But his yard, there's a toilet right up in front, a speed limit sign.
Great artistic minds sometimes
Yes,
are.
but I've seen I've seen the inside of his home.
Yeah, I understand.
Okay.
Yeah.
It's really not even a livable place, but I've seen him come out with the trash cans and literally just dump. So their trash is coming from his house, from the other one's house, or coming into my yard, in her yard, and the window.
And I feel bad to delay issuing the order, but my issue is that I have to be able to explain it, why it's right, against all possible defenses. On all the other orders you've heard today, I have no trouble doing that. There's one unique issue here that I don't know that I can address yet without reading the proper briefing. So I expect to issue an order in March, at the March hearing. I have to announce it at an actual hearing. I can't just do it at home. So I'll announce it at the next, based on what's been given to me today. And I've already told you where I'm leaning. I just have to be able to defend it, because if I'm wrong and there's a legitimate basis for appeal, then this whole thing gets reset and it might even get dragged out longer. So it's best to be right.
And there's at least 4 vehicles on that property.
Oh,
But
look,
it's
I've seen the
behind
photos.
fences and stuff.
I've seen the photos.
You've already adjudicated the vehicles.
Yeah, I adjudicated the
Yes,
vehicles,
sir.
that's right.
The signs in rights.
How much time did he have to
They're not
comply?
even
Is that
real words.
It was a
most of
30-day order, I believe.
okay?
I believe it was 30 days.
Yeah.
And that's coming up.
Yeah,
to
real
here
soon.
tomorrow.
But if he doesn't read his mail, he will take the lawnmower and cut it all up, the sidewalk and all that. All those.
Well, you know, like Mr. Johnson pointed out, I did issue an order finding the property in violation on the cars already. If that's not corrected by like today or tomorrow, sometime soon, then a fine will begin to accrue. Now, ultimately, that's pretty much all my power is here. That's why. Well, it's fines. Sir, have you been sworn in?
Yes.
Okay. Yeah, I mean, so
Well, there's liens against his house.
it's possible that the county.
And this is a process too, though, so it'll be other things going.
It's possible that the county could also foreclose if it remains a lien on the property, but that's a decision that's way beyond my purview. I just want to explain. Well, first of all, let me give you an opportunity. Have you said everything that you would like to say about the property?
Everything keeps coming out every day. He brings something else out there on the west side of his house every day.
I just want to say, we're not trying to be mean to Steve or anything like that.
Tried to help him
It's not,
create
you know,
a peace for 3 years
a
until.
punching match or anything. We've even tried to leave him alone because sometimes it seemed like it worked more that way. You know, he would sometimes clean the property up. My dad and him, they did have, you know, punching matches like all the time.
Wow.
Verbal punching, you know, bad. And, but
My husband even tried to be nice to him.
yes, we've tried. I've tried to give him things, you know, like
He had
we had a
peace for
yard
about
sale one
3
time.
years.
I tried to give him a pair of high back bucket seats, you know, for his, but he's threatened my mother, you know, he's threatened me. I don't care if he threatens me, but when he threatens my mother, then I start having a problem, you know, and actually called the police out there, and they went over and they'd come back 5 minutes later and said, well, we asked him to quiet down, you know. Well, that's not curing anything, you know.
Well, I mean, I appreciate the feedback. I understand how seriously you guys take it, and I'll keep that in mind when I make the decision.
And
I wish
nobody wants to
everybody
live
lived
across
on,
the street.
I mean, they had this in front of their driveway. I'm
If
sure
mom
there'd
wanted
be
to
a
sell
lot
property,
of conflict.
you know, the property value is gonna be, how do you sell your piece of property if you wanna move with, you know?
I understand.
Is there anything else the county wants to say about the case?
I believe you have current photos.
I do have
Oh,
current photos.
okay, yeah.
It has gotten, it has adjusted with more junk. And to be fair, I have on the exhibit slides.
I'm sorry, guys, if you
just a
wouldn't mind,
minute.
I'm just trying to hear from Mr. Jonason.
For the slides that I've selected to show junk, graffiti and verbiage out of the picture, just specific junk and debris on the property. I do have specific examples of those in the slides, in the photos, to
Yeah.
show you if you're interested in
Whatever
seeing
you want
those.
to introduce, this hearing is open. I haven't closed
Okay.
it.
Would you like me to begin from the?
No, I'm interested in your evidence. I mean,
Okay.
I don't need formalities.
Okay.
All right, so what I think we'll do is it's labeled as Exhibit A, but we've continued the hearing, so I'm going to make this Exhibit C.
Okay.
Okay. Let me take a look at it.
And I can point you in the right direction as far as what the county is looking at for junk and debris on the
Well,
property.
look, I certainly agree that to the extent that the county can distinguish from anything that could even be arguably called art, you know, versus just pure junk and debris, there's going to be a violation. I'm not going to make a ruling today.
Okay.
I think I need to consider all this together, and the worst case scenario then for the county would be that I issue an order finding that parts of it are protected and other parts aren't, and that stuff has to get corrected. That's the worst case scenario based on what you're telling me, which I think if we do peer into this, we probably can find junk and debris that.
Does it have pictures of his blown up rubber?
I just saw that. I hadn't seen that before. I hadn't noticed it before. Let me put it that way.
He honestly, I haven't seen him lately, though, but he always had these female doll effigies naked, hanging through the trees and on fences.
Well, that's certainly a different kind of expression, perhaps. It's not something I'd pay to go look at,
Where can a private citizen find these codes? Because that one directly across from me is a
codes?
violent.
Where can you find the codes?
Yeah,
Online?
which-
They're
which-
online.
What you can get by with and can't.
Yeah, look at
On
the land development code is available online, I believe.
Citrus County website.
I think I see some stuff, Mr. Johnson, that you.
Did you see the list he's got, what in each exhibit?
I don't have a list.
I didn't give him the list. I have the list, and I was gonna.
I don't mind. Yeah, I mean, look, I don't want to
can-
deprive you of your presentation. No, I mean, if you want to, but I take the point.
You want this to refer to?
All right, fence pickets used to hold up fence panels.
So those fence pickets are designed to be fence pickets, not to hold up a fence in that manner. And then if you look, the next comment, Exhibit 2, Slide 2 and 3, fence panels on the ground, along with wood debris, discarded shoes, bicycle rims, that sort of thing. That was on 2 and 3. On Slide 5, there's a folding chair on top of the fence. And then there's a discarded, looks like a recliner next to the wheelchair. In Exhibit 5. Exhibit 6, Slide 6, there's tree debris and more fence pickets just sitting there.
Yeah, I mean, this does not look good.
Slide 7, discarded auto parts, fenders. There's a wheel there that should be on a vehicle. There's a vehicle door, bicycle rims, another wheelchair, and tree debris. On Slide 8, the vehicle tire, and then there's a door to a vehicle. It's a door panel, and then there's a bicycle rim. Some of these things are repeated. You can see them in more than one picture. On Slide 10, there's household trash and other junk and debris, clearly visible in the slide. Slide 11, there's tree debris, shoes, and vegetative matter on the ground. Slide 14, there's an inoperable bicycle, tree debris, and wood panels, what appears to be wood panels lying on the ground. In 16, there's now a discarded washing machine and tree debris.
Well, to me, the material in page 19 is really good evidence for you.
You got ahead of me.
Household. I mean, I can read it.
Sure.
Okay. The household
Sure.
trash. It's hard for me to imagine what.
You need to go by.
No, and on some of these, some of these things, I can imagine reasons why it would be a part of an art installation. I mean, I know it sounds crazy, but listen, they'll put a shoe in a corner of a room in an art museum and call it some kind of.
That's in a museum, though. That's not
It
a
is.
residence.
It is, and yet, if it is art in a museum, then you might have a First Amendment right to express that same kind of art somewhere else. So
That explains the toilet thing. I mean, I remember I did.
yeah, Duchamp's urinal in the Paris Art Fair in 19 whatever. It's unfortunate.
But as this young lady over here spoke on the other case
I'm not sure if that's evidence. It's important that I know that, but I don't know which way that cuts. So what I need to be able to do is to consider this and make sure that I'm right, that it is a violation, and I'll issue the order in March.
Thank you.
All right, thanks.
Thank you.
The Supreme Court case is Reed versus Town of Gilbert.
Okay.
And it came out in 2015, so not 17.
Is it mentioned in your memo?
No.
Okay.
Because my memo just says what happened
Okay.
in that case. But the citation is 135 Supreme Court 2218.
All right.
And that has to do with speech, regulated speech. And
Right.
our ordinance
Right.
isn't regulating speech.
No, but the way it's enforced may act as it, and that's my concern. So,
Ready?
I'm ready.
All right.
Yep.
Next case on the agenda, G Research Analysis Limited Liability Company. Case number 2179479, Code Officer Cody McGuire, page 11 of your agenda.
Oh, I don't need to. Already been sworn.
I'll do it again though. All right. Cody McGuire, Citrus County Code Compliance Officer. This is a repeat violation. Initially observed on January 9th, 2023. The address of the violation is 9632 West Plantation Lane, Christopher, Florida. Case number 2176879, accumulation of junk and debris. A violation of Chapter 20, Article 3, Section 20-30A of the Citrus County Code of Ordinance. The property owner, G Research and Analysis Limited Company, has been previously found guilty of the same violation at the same location on October 13th, 2021. Case number 2152573 with $0 in imposed fines. That violation was abated on March 22nd, 2022. Good service, posting of the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, findings of facts and an order of acknowledging compliance from previous case 2152573. Exhibit B, photos I took during my initial inspection of the repeat violation on January 9th, 2023, and photos I took during my follow-up inspections on January 17th, the 20th, 27th, February 1st, 3rd, 8th, 10th, and photos of my final inspection on February 14th. Exhibit C, a copy of the notice of violation and hearing sent to G Research and Analysis Limited Company, a copy of the posting affidavit I have completed, and photos of the posting of the property.
Is there anyone from the public who wishes to be heard on this case? Let the record reflect that there is no one. Thanks. Without objection, what's been proposed as, let's see, is it just, A through C is evidence. Please proceed.
Okay. I conducted my initial inspection on January 9th, 2023, and observed that the property was in violation of junkyard conditions. During my follow-up inspections on January 17th, 20th, 27th, February 1st, 3rd, 8th, 10th, I observed little to no change to the property. As of my initial inspection on February 14th, 2023, the property remains in violation. I have not had any contact with the property owner.
Thanks. Let me read this old order. I do remember this case. Okay. You've had no contact?
No, sir.
Has there been any? Oh, okay. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $300 per day along with administrative cost to begin on the date of the posting of the property, January 11th, 2023, and continue until February 14th, 2023. That would be 37 days at $300 per day, totaling $11,100, and a fine of $300 per day from the day forward until the violation is abated. We would also ask that the special master find that it is the respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for a reinspection.
I adopt the county's proposed findings of fact. I'll assess a $300 fine per day from January 11th through February 14th. Is that 37 days? I thought you said January 11th through February 14th.
January 11th through February 14th.
January the 11th.
I mean, that can't be 37.
I think it's 34.
Maybe
No.
27?
It's something like 34.
Until the 14th?
Yeah.
Yeah.
Yeah, for like 34.
34 days.
34 days.
Okay, so for a total fine of $10,200, and then $300 per day from today's date forward, to the extent that it's not brought into compliance. And I'll incorporate all the other standard order provisions.
Thank you.
Thanks.
Next case on today's agenda, James Schooler, case number 217-8087. Alan Jonathan, code officer on the case, page 20 of your agenda.
Alan Jonathan, Citrus County Code Compliance Officer. This is case number 217-8087, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address of the violation is 3611 East Yandle Place, Inverness, Florida. Property owner is Schooler James. I have good service being via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 7 December 2022. Photos from my compliance inspection on 9 January 2023. And photos of my final inspection conducted on 14 February 2023. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
Is there anyone from the public wishing to be heard on this case? Let the record reflect that there is no one. Thanks. Without objection, these are exhibits A and B in evidence.
On 7 December 2022, I conducted my initial inspection and observed the property to be in violation. On 8 December 2022, a notice of violation was issued for junkyard conditions, which is a violation of the ordinance listed above. On 9 January 2023, I conducted a compliance inspection and observed that the property remained in violation. I have not had contact with the property owner, and as of my final inspection on 14 February 2023, the property remains in violation.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 per day along with the administrative costs to begin after the date you deem sufficient to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I adopt the county's proposed findings of fact. The property is in violation. The owner is granted 30 days from today to abate the violation. If the violation is not brought into compliance as ordered, a penalty of $50 per day will be imposed and otherwise incorporate standard provisions.
Thank you.
Thank you. I believe that concludes the agenda. The time is, 12:25. This hearing is adjourned.